Justices of the Appellate and Fourth Department, hear ye, hear ye, hear ye. All persons having business before this court draw near, give their attendance.
Good morning, and please be seated. First case for oral argument this morning is 976, People versus Figueroa. How do you say it?
Figueroa?
Okay, that's good. I like it, that's good.
Good morning. Jonathan Garvin for Mr. Figueroa. May it please the court. I'd like to focus my argument on the court's failure to conduct a Lopez inquiry after Mr. Figueroa's repeated and unequivocal denials of intent. Under that situation, during a plea colloquy, one of two things must happen. The court has a duty to do a Lopez inquiry, which accomplishes two goals. One, the court is required to make sure that the defendant understands that his statements do not necessarily make out the crime being charged, that he's negated the intent, and two, whether having that knowledge and having that understanding, the defendant, he or she, nevertheless still wants to plead guilty. That's not happened here. And that failure to conduct a Lopez inquiry requires that this court remit the case back and allow Mr. Figueroa to take his plea back.
We'll look at that very carefully.
Thank you, Your Honor. Okay. And it's what
We have the whole transcript so that we can look and see.
Okay. My time is brief. I just want to make one sentence. One sentence. I just want to explain that I know you have the transcript and everything, but not only did the court fail to do any inquiry at all, well, what it did say was actually an incorrect statement of the law, which taints all the subsequent statements. The court conflated the elements of intentional and depraved indifference murder. And it was only after that the defendant did eventually give a one-word answer, yes, that he did intend to commit the crime. But based on this record, there's no way to know whether he was confused and didn't have an understanding, that he could have very well believed that if he had a complete disregard for the victim's well-being or just didn't care whether she lived or died, as the court instructed, then he was guilty of intentional murder. Based on this record, we can't say whether he had that understanding, and that's a second reason why this case should be remitted so Mr. Figueroa can take back his plea. If there are no further questions, I will rest on my papers.
Thank you.
Thank you.
Good morning, Nancy Gilligan for the People. To determine whether Lopez inquiry is necessary, the entire plea colloquy should be examined. And in this case, the defendant was really unequivocal when he said, I didn't intend to kill her the first time I stabbed her, but after everything else, when I finally hit her over the head with a hammer when she was still moving, I did have the intent to kill. There was no conflation by the court with regard to what defendant was pleading guilty to. The word "or" is in there, and he was merely just trying to explain to the defendant, look, everybody sometimes has reluctance admitting, their involvement in crimes, be it an intentional murder or a depraved indifference murder. So I think "or" is significant when looking as to whether or not the judge gave any inaccurate language to the defendant. Thank you.
Thank you. $978, People versus Clinton. Just one moment. Okay. Can you unmute yourself, please? Thank you. Oh, nope, still muted. You're still muted. Can you unmute yourself? There you go. Thanks. Go ahead.
Good morning, Your Honors. Skip Lazier of counsel to the Monroe County Public Defender for Corey Clinton. The trial court in this case abused its discretion when it seated a prospective juror over objection on English proficiency grounds. And it also illegally imposed consecutive sentences for murder and weapons possession when the people failed to prove possession before intent to use the gun. Starting with the jury selection, all that was required by the judiciary law is that a prospective juror, be able to understand and communicate in the English language. It must understand the evidence, be able to evaluate it, communicate effectively, and comprehend legal principles. Nothing in the record establishes that juror number 9 failed in any way to meet those qualifications.
Mr. Lazier?
Yes, sir.
Can you hear me okay?
Yes, I can.
Great. How is it we know why the court excused this juror? What in the record tees up the idea that this was the specific reason or these were the specific reasons for excusing this juror for cause? How do we know that?
Okay, so during voir dire, 3 times the court said that that the juror seemed fine, seemed able to communicate, had very good English, and only when there was an inquiry at the end during one of the challenge conferences did the court ask the prospective juror, "Do you remember my talking about reasonable doubt?" The court didn't ask, "Do you understand reasonable doubt?" It asked, "Do you remember?" And he said, "No, I didn't remember that." That was not a statement of inability to comprehend legal principles, and in fact.
But how do we know, Mr. Lazier, pardon me again, sir, I'm sorry, but how do we know that the failure to understand as opposed to an English language barrier was at the root of the reason or reasons for excusing the juror when there was no objection by defense counsel to the for cause ruling at all, because that would have teed up the reasons. I think that's my point, is that by the time the jurors interviewed, privately, as I understand it, we have nothing on the record teeing up as to the court's reasons, and an objection, obviously, or exception or something, would have teed it up. Don't you agree?
I don't agree, Your Honor. The counsel did not specify English proficiency as the reason for objecting to the strike. But as soon as he said there's insufficient cause, the prosecutor went into why he believed that the juror did not understand English well enough, and the court then conducted an inquiry about whether the juror understood English well enough. So under those circumstances, there was no need for counsel to be more explicit. Everyone knew what was being discussed here, and there was no other possible objection to juror number 9 that the prosecutor could have interposed, and he did not do so. So it's clear from the context of the conversation and the inquiry that the reason that the court allowed the strike was that it considered. It essentially deferred to the prosecutor's belief that the juror was insufficiently qualified. The one other point to make on this is that there's a case, Johnson, which under very similar circumstances found that the for cause removal was improper, and that was a case where the defense was trying to do it. And that involves, of course, the defendant's right to a fair trial. Here it was the prosecutor who did it. And so this case is even more is more strongly desirous of a court, being careful about dismissing a juror under these circumstances.
Do you have anything further?
I'll point out that the prosecutor was free to use a peremptory challenge, and that there was no real need for the for cause to be granted. The other thing I'll say is about the sentencing. I want to point out that it was a people's obligation to show that Mr. Clinton had a gun before he formed the intent to use it. In this case, he was inside the store when he encountered Mr. Taylor. Don't know whether that's when he got the gun and decided to use it. And if that's the case, then he did not have the gun before intending to use it against Mr. Taylor. And people say, well, there was 15 minutes. He could have had the intent to use the gun for any number of minutes. The point is there was no evidence that establishes that he had the gun at a time when he did not have the intent to use it. I'll give you an example of what could have happened. Perhaps he's in the store. He knows the store owner. He knows the store owner has a gun under the shelf. He sees Mr. Taylor come in. He grabs the gun. That's the kind of thing that could have happened.
Mr. Leisure, I've looked at that video. That clearly didn't happen. So that's pure speculation, and I would respectfully submit contrary to the record. But putting that aside, there were eyewitnesses to this crime, and there's a pretty good video, such as it is, and no one testified that the video showed, and nobody that saw this happen testified that they saw anyone approach the defendant between the time that he was in the store and the 15 minutes later when the crime occurred. So isn't that pretty darn strong evidence that the defendant already had the weapon on him?
Well, I don't think so, because the video doesn't show what happened in the store. So we don't know what possibility of his obtaining the gun in the store was.
Well, even if you got it in the store, there's like 15 minutes later, he had the gun the entire time then.
And he may have intended to use it the entire time. There's no proof of when that his intent was different. The case is.
Okay, we'll look at that very carefully.
Okay, thank you, Your Honors. That's all I have.
Thank you.
Good morning. Marty McCarthy for the people. So when defense counsel objected to the exercise of the cause challenge, the reason for it was that the juror didn't raise his hand at any point during the voir dire, indicating he didn't understand.
The court specifically invited the juror to do exactly that.
In essence, it was sort of a provisional seating. Please raise your hand.
If you don't understand something,
Don't understand
let us know.
something. So that when that happened, defense counsel then said, I don't think we have enough here. And my reading of it is the court agreed and said, yeah, let's bring him in and find out whether he was understanding or not. They bring him in. The juror starts to express doubts as to whether he should be sitting on this jury because he was concerned about his English language issues, and he wanted to make sure he understood everything. So the court then tested him whether he did understand everything. Asked him about reasonable doubt. Now, it wasn't just that the court instructed or talked about reasonable doubt. The attorneys also talked about reasonable doubt. He didn't remember that at all. So, in essence, he wasn't following instructions because he heard something he didn't understand. He didn't raise his hand. At that point, defense counsel could have asked all the questions he wanted, as you pointed out, Justice Kern. He didn't. And when the court excused the juror, defense counsel didn't object. And it's at that point, for that reason, that the issue is not preserved. And with respect to the gun, the video is very clear. You can see inside the store and outside the store.
What about Mr. Leisure's point about he may not have had the intent or may have had the intent that whole time, and there's no proof that you provided that shows the intent?
So with respect to that, first you watch the video inside. It's clear he doesn't get a gun from anybody inside the store. You watch the video outside the store. It's clear he doesn't get the gun from anybody outside the store. So he had the gun prior to even encountering Mr. Taylor. So
outside a home of business.
Yes. And in that sense, like, he wasn't there to meet Mr. Taylor. There was no proof that he knew Mr. Taylor was going to be there. He was just there sort of, living his life with a gun on him. Mr. Taylor shows up. And the other interesting thing is when they come out and they're standing outside, they're talking for 15 minutes. And during that time, the defendant gives Mr. Taylor money, right? If he was going to shoot him, why did he give him the money? That doesn't make any sense. So clearly something happened after the point where he gave him money and when he decided he wanted to shoot him and kill him, like he shot him point blank. Something happened in between that period of time that triggered the defendant to shoot Mr. Taylor. And in that sense, that's the distinguishing feature between intent to use unlawfully and outside home or place of business, such that the sentences were justified to be run consecutive. Are there no questions?
Thank you.
Thank you.
979, People versus Sumler, I'm sorry.
Same thing.
Good morning, can you unmute? There you go, thank you.
Good morning. May it please the court, Brad Keem for Mr. Sumler, the appellant. Please note that appellant's statutory speedy trial rights were violated. We recognize that these
Mr.
trials.
Keene?
Yes.
Good morning, sir. You're just out of the box, I know.
Yep.
I have a number of questions. In looking at your brief, you referenced the term or phrase law enforcement disciplinary records, correct?
Correct.
Do I have it right that that's what we're talking about? And what I
Yes,
mean,
we're not.
forgive me for talking over you again, but just to fine tune it, what we're talking about is law enforcement disciplinary records that is defined in the public officers law with respect to FOIL, which evidenced the other half of the repeal of 50A. So what you're seeking is law enforcement disciplinary records as defined in that statute. Do I have that correct?
Yes, Your Honor, not personnel records. We're talking about disciplinary records.
What you could get through FOIL, you're thinking they have a burden to automatically produce.
Correct. And we would point the court to several miscellaneous cases that have held just that.
Before you do that, Mr. Keeman, just so you know, I can assure you that every member of this court has seen a lot of these cases already and has reviewed many of those cases. So, I mean, it's no secret this is sort of a big issue at the moment in criminal law. But, so I don't want to steal your thunder. We're very familiar with those, I think. So
That's fair. That's fair.
And so, all right,
Unfortunately.
we're talking about law enforcement disciplinary records as defined in the public officers law. Now, you would understand that that means that under the public officers law, certain redactions can be made, right?
Certainly.
Okay, secondly, there is a phrase, and I may have it wrong because I didn't pull it up on my computer here, but technical infractions are not foilable. And I think that's the phraseology, and it's defined there. Do you remember that there's that exception to the requirement to produce law enforcement disciplinary records?
Yes, but there's a couple of issues with that. Is in this case, okay, there's no indication that that's what the non-provided disciplinary records entailed. There's no protective order either, which is something that they could have easily done.
Hold that thought. That's exactly where I was going. If the position of the prosecution is that the records at issue, again, meeting the overall definition of law enforcement disciplinary records, and you know that's defined as records that result from a law enforcement disciplinary proceeding, but then if you look at the exception having to do with technical infractions, whatever that is, you say no protective order, but doesn't the prosecution have the ability where it thinks that the law enforcement disciplinary record is a technical infraction to withhold the record on the basis that it is not within the statutory definition of law enforcement disciplinary record? Isn't it their prerogative in the first instance to make the determination under the law that this is a technical infraction and this is not? So in other words, they're saying that's not subject to the statute and that this is. It's a question of the law that they're interpreting. But don't they have the right to do that?
I think that is a slippery slope because it filters the information and it prevents defense counsel from having what the prosecutor may think is, in your term, forgive me, it's it's technical. Yeah, technical infraction.
Close. Right.
Yeah, what it means to one person may not mean the same thing to defense counsel. And that's why I think, we have the ability to do a protective order. I think we're giving too much.
I agree with slippery slope is, of course, that's what we deal with in the law all the time. But putting that aside, let's assume that it's an equipment violation. You didn't wear your badge or something like that. Let's assume that most reasonable people would agree that's a technical violation. Don't the people have the authority to withhold it on that basis? For protective order.
I guess if that's what it was, but we don't know that, and I think it gives the people too much control over what the discovery changes were really meant to liberalize the documents that defense counsel is receiving.
But that's what lawyers do all the time. I mean, my background is primarily civil practice. When I signed a document indicated that we had produced everything we had, my career was on the line, I thought. So that we do that all the time. So that's what I'm struggling with. I'm still stuck on the what. Let me take you to the next thing that's bothering me. So if the what is law enforcement discipline records as defined under the law, okay, we'll figure that out. Then the question is, what is impeachment? County court here defined impeachment as basically the statute had only codified Giglio and Brady. And that's what the county court seemed to say. Is that wrong? That is, don't you think the legislature, certainly, they didn't say anything that impeachment meant something more than Giglio. So doesn't the impeachment language in 1K4 mean Giglio?
I think it means more. It means defense counsel should receive these documents and should have an opportunity to decide whether or not they're potentially impeachment material. And Your Honor, I know that you're focused on the officers that the people did not provide. But if I could stress, I think the COCs are all invalid because they provided a summary of the officer that they did provide. They didn't provide the actual disciplinary history. They provided a summary of that officer.
But what if under Giglio a summary for certain things was enough?
I completely disagree that it is enough. And the first department in Jason C., which I know the court is very well aware of, found that a summary doesn't satisfy 1K4. And I think that the court should adopt that finding. A summary can never, it just can never be enough. It's the single-minded, zealous representation of defense counsel that needs to see the entirety of these documents.
All right, let's turn, so I'm still stuck on the what. Let's give an example. Let's assume that a defense has an alibi witness. They're going to put the alibi witness on the stand. And they give notice of the alibi. So you now know that that person is likely to testify. So do you, as defense counsel, have an obligation to find out if they ever have any work history that they were disciplined as part of it and turn that over?
If the alibi witness has work history
of discipline.
I mean, I think that's different. The Court of Appeals opened up what law enforcement, I mean, they're held to a higher standard by jurors time and time again. They should.
But it's reciprocal discovery is what the legislature did here. So, you know, if the people have to turn over this work history, wouldn't you agree that the law, and so what tends to impeach a testifying witness? If impeachment is these law enforcement disciplinary records, shouldn't they also be for alibi witnesses? Anything in their work history? Let's assume somebody works for the government and they were disciplined through some Article 75 under the Civil Service Law.
Yeah, and Your Honor, it's an interesting point and an interesting thought exercise, but what's before us now is the disciplinary history of these officers. And it's squarely put before this court by, I think, some excellent objections and a motion. And I think that the trial court got it wrong, that we need to set a standard that these disciplinary history needs to be provided in totality, not in summary, in totality.
King, you know, your brief makes all those points in a very good way. A lot of this, as you say, is teed up. That's why I'm spending the time with you and likely to do with Mr. Osler and taking my fellow colleagues' time here too, to kind of highlight this. Because then the question is, if we're going to define what all this means, what the what is, in terms of the terminology I've already gone through, if we're now going to define it 3 years later, close to 4 years after the statute was adopted, wasn't it good faith for the people, as they argue in their brief, to say, hey, we're doing the best we can to apply this brand new statute that is a complete change in law, and isn't that good faith and reasonableness to say, we're doing the best we can without a definition? How is it we should now, 4 years later, say, you got it wrong, speedy trial violated, indictment dismissed? Isn't that a good argument that they've exercised good faith by trying to comply with the law?
I think there are cases that perhaps have been before the court, that would be true, but it's not this case. This case, there was 6 total certificates of compliance. And there was an initial followed by 5 supplementals that didn't have really any explanation as to what was going on. The people said in January, February, and April of 2020 that there was no Giglio material. It was only in July of 2020 that when defense counsel had to make a specific request for the disciplinary records, that they even came out.
Because you weren't entitled to them before June of 2020.
That is true, entitled to them based on the Court of Appeals decision, but you would still say that you would still define them as Giglio, I believe.
In any event, Mr. Keems, thank you for putting up with all my questions today. I'm really doing the best I can to sort it out. Justice Smith, I appreciate the extra time.
Justice Smith always likes a long oral argument.
Whoa, what's that mean? What's that about?
Anything further, Mr. Keem?
Yeah, good luck, Mr. Keems.
I appreciate the court's consideration of this issue. And
You reminded me of the Buffalo Bills at the morning.
I'll rely on my brief for the points, not argument.
Thank you.
It's too soon to talk about Buffalo, Your Honors. Brad Osler for the people. I want to respond to a couple of the points just brought up. Maybe I'll go a little bit in reverse order. I think first I would agree, and I think our brief sets forth that in light of the changes of the law, which were drastic I think at a minimum, and then with the addition of the repeal of 50A that occurred 6 months after the start of 245, I think what the people did here was...
All during a worldwide pandemic.
Also that. I think it was reasonable. Now, I think that Jason C. case from, I believe it was downstate, if I'm not mistaken, I think that's actually a nice illustration of what might maybe be unacceptable disclosures by the people versus what I would submit here were acceptable. In Jason C., I believe the people's disclosures were something to the effect of there are some records that exist or there are not records that exist, and just left it like that, very kind of broad language, no hint given at what those records might be, just that they might be, in fact, Giglio or Giglio, however we want to say it. That's another debate we don't need to get into. Our disclosure here, which I think is on 147B of the appendix, described in, I think, a reasonable amount of detail exactly what the disciplinary record was here. The officer had used a vehicle when he was off duty, and
That was in a summary.
That was the summary. Mm-hmm. Now, I imagine that it is put out in slightly more detail in the actual record itself, but nonetheless, the defendant here was apprised of exactly what the disciplinary record was about, why it would fall under this disclosable...
This was a committee that made that determination on what was going to be supplied. Is that correct?
It was. It was, yes.
And what if the committee makes a determination, well, this part is okay, this is not, yeah, he did use his vehicle, but maybe there's something else in there in that disciplinary record which defense counsel should have the opportunity to review and use as impeachment material.
And that might be the case, and I don't think that had the defense requested that specific record in total, that I don't think we would have, the people would have been able to stand back and say, no, you can't have the actual document. I don't believe there was, I don't want to swear by that, but I don't believe there was a specific request of that nature made here.
Do they have to make that specific request? The statute says all.
True, it does, and I think this is an example of maybe it would be a better practice to just turn over the record itself, then we don't have to have the debate about is this enough detail. However,
Mr. Osler, on that line, but a summary, I mean, your office is full of trial lawyers. I don't imagine a trial lawyer being satisfied with just getting a summary of somebody's deposition.
Fair enough.
You're going to want the deposition. You're going to want the record. That's what because otherwise the officer can be on the stand and say, I don't know what that document is. That's a summary the DA's office gave it to me. That's not good enough. So trying to say that a summary is good faith, unless it was allowed under Giglio, and I've taken a brief look, couldn't find that. But I didn't find it, nor have you cited it. So the summary itself, why is that good faith and reasonable?
I think it's good faith and reasonable, given the amount of detail that was provided. Now, I recognize that I would not argue that the people would be able to refuse to disclose the record itself upon request.
But that's what happened here.
I'm not aware of the defense requesting the entirety of that particular record.
They objected to the summaries.
Well, if that's the case,
I'm sorry, I infer from that they were looking for the records themselves.
I took the objection to be really directed at the lack of other disclosures, essentially, with respect to the other, I think, 3 officers that were involved. Now,
you say the 3 officers were involved. So this is the impeachment material. So I did the what with Mr. Keem. I'll do the who with you. The who is the 3 that testified, right?
There were 4, I believe, total, and 3 of the 4 testified.
I had Coleman, Bates, and Cozzoli.
Correct. There was a Townsend that was involved but did not testify.
Newman, what about Newman? Wasn't there a Newman?
There could be. I wouldn't say that there was, but if that's
My
the case.
notes, Newman did not testify. That's what I'm drilling down on here, too. The statute says you get impeachment materials for testifying witnesses.
Right.
And as I understand it, the statute under subsection D, 1D, says that you're supposed to identify the law enforcement officers who have information or evidence relevant to the crime or defense. And then in addition, you're to identify those that may testify.
Correct.
Did you do the may testify thing, or did you just do in bulk? Here's 12 officers. And don't you think you kind of need to tell the defense, at least as of the time you file a certificate of compliance, who may testify as the statute requires?
I believe our disclosure was sort of more of your bulk description. Here are all the officers involved.
Your office is not alone, by the way. We see other appeals.
I would imagine. But I don't find that surprising, because I think, again, given that we are required to disclose this material within, I guess at that point in time, it had been expanded to the 30 days.
But when it comes to impeachment materials, if you haven't told the defense who you think is likely to testify or may testify, then don't you have to turn over all these records as to everybody you put on your list? That's what I'm driving at. The who.
I would agree that it would. I think if we are going to assert that every single person may testify, the same or the next or K1 before or whatever it is would imply that, well, all of those officers then need to have their records disclosed.
But now that we've had a trial, this is a different case, because now we know exactly who testified.
Right. I think it is inconsistent to make a disclosure and say, well, everybody could be a witness, and then to only selectively disclose records for certain officers. However, I don't think there was a violation of that here, in as much as the people asserted that there were no records to disclose on the other officers. Now, this is sort of the second half of the issue. I don't think it is reasonable to ignore the related to the subject matter language in 245.20. Much like the Giglio requirement, it is records or evidence that would impeach the testifying individual or testifying officer. The people, by asserting that there were no relevant records for the other officers, while I think that's acknowledging there might be other disciplinary records, say for technical violations or for unsubstantiated complaints, things of that nature, those, it's my position, are not required to be disclosed.
Mr. Oster, on that point, that's what I was driving at with Mr. Keene. If all the statute did was engraft Giglio in terms of defining the word impeachment, the part of the what, then we've got a case, and others, a case called Fife, F-Y-F-F-E from 98, and it quotes Bagley and Giglio. Absent a connection to the crime charged, it was collateral, the Brady material, and it was not otherwise the kind of material required by the courts to be supplied to defendant for use to impeach a witness. So it could be, if Giglio has been engrafted into the statute effectively, that we have to look at exactly that. Does it have to relate to the crime? Maybe that's what Johnson meant, maybe it didn't.
I think, not to cut you
go
off,
ahead.
but
I'm obviously struggling with it.
I think that's effectively why that related to the subject matter language was included. view 24520 as requiring just a flat-out blanket disclosure, all disciplinary records, period, technical, non-technical, substantiated, unsubstantiated, just removes that clause from the statute. And I don't need to tell any of you, Your Honors, that the way we interpret statutes for time immemorial is to give meaning to all of the words that are put into that statute. So to say that...
The statute does use the word summary in a couple of other contexts, but not here.
No, I can address that. I mean, what I'm getting at is more with respect to the actual disclosures made, or the people's assertion that, well, there are no records for,
I
such
appreciate
and such.
that. I'm going back to the summary.
But with respect to the summary and not listing it here, I think, again, the comparison to Jason C., I don't want to hammer this point unduly, but the people, I would have to agree, did not make a sufficient disclosure in that case. But here, the people provided in detail exactly what the underlying behavior and disciplinary action was.
But for a particular case, you have two things. You have the nature of the disciplinary record, what it says, and then also the officer's role in the present case. And depending on what that is, you could have a disciplinary record that's irrelevant in one case, but then when the officer takes a stand in the next case, because they had a greater role or a different role, suddenly that becomes very relevant as impeachment material. Why is it that and it would seem to me that if you can provide a summary, that then places a burden on the defendant to come back and say, all right, we've received the summary, but now in this case, the officer's role is different, and therefore, Judge, in this case, we need to get the actual record. It seems to me that providing a summary creates this additional burden on the defense, and I don't see in the statute that burden was contemplated.
I would disagree just on a couple minor points, I think. Number one would be that the defense does have an obligation to challenge the people's 245 disclosures if they feel it is deficient. And they're meant to do it in a timely fashion so as to avoid lying in wait and then springing a 30-30 trap, essentially, for the people. So there is a certain level of burden that the defense has to undertake after the people make their initial disclosures. With respect to the changing nature of a disciplinary record, depending on the case or the officer's involvement, I think that may be true. I also think that by and large, if there's a report, and the one in this case might kind of be a good example because it was indicative of dishonesty by the officer. That's the kind of thing that I don't know. I mean, it's hard to imagine a case where that should not be disclosed.
Credibility is always an issue.
Right, but there's plenty of reports that don't speak to the honesty of an officer.
I'm sorry, Mr. Rochester, I'm trying to respond to Justice Novak's question, I'm sorry. But using that as an example, so let's assume the officer's on the stand and has the summary, or even the record for that matter, that he or she, I think the example is lied with respect to using a patrol vehicle for an after-hours job, right?
Yeah.
And the officer looks you right in the eye in cross-examination and said, didn't you do that? No.
What do you do with that?
What's next? Isn't it collateral? You can't introduce that evidence. Now, relevancy is probably not the standard, I'll give you that, but that's what's...
That's a limitation or a difficulty, I suppose, that a defense attorney, if the officer was going to, I suppose, double down on the level of dishonesty, I suppose, which hopefully doesn't happen anywhere.
If we don't have any more questions on all this, do you have something else you want to?
No, I think
we've got a lot on our mind.
No, I understand. I'll end with just one final point, and it's just to...
Before you end with it.
Oh,
I got a question concerning, all right, let's take for granted that the 6 certificates of compliance are all invalid. Mm-hmm. Do you still have time?
I mean, I think at this point, I don't know how we could.
Only because I'm making that comment is looking at Judge Dorn's decision, he really doesn't do much of a calculation on the time. Because we indicated there was a pandemic here, there were a number of motions here. Again, those are situations or time where it's not chargeable to the people. So is there anything left of the 183 days?
I mean, I wouldn't want to...
Well, I don't know if you can do that calculation now. I mean, that calculation should have been done by the trial court.
It's possible. And if there was time left counting the COVID delays and all that.
Then you'd have the opportunity to make a proper or whatever.
That might be a possibility,
whether or not,
yes.
more records should have been supplied.
Yes.
I mean, So right now, we don't know. I mean,
No,
the court
and-
below didn't make that determination.
Right, and I mean, this is, I fear that there might be a lot of cases where there's questions like that left unanswered. I don't know if remittal is an appropriate remedy or not. It might be if it's just a question of, okay, let's do a calculation and
How much time is
Figure
Right,
out.
because here he didn't really, he made, all other periods are properly excludable from the calculation based upon the filing and argument of motions, requested hearings by the defendant, and periods during which CPL 3030 was suspended by executive order. So he's just making that general statement. He didn't say there's dates from here to there,
Right.
there was a motion made and eliminated, the judge reserved decision on this, and all that time is now not chargeable to people. So we don't really know how many days are chargeable to people. We don't know if there's extra time that you have left.
that is true. I mean, that's
I'm not asking you to do the math right now.
If you can, please do.
No,
I got a pen and paper if you need
I'm
it.
not in a position to, I'm sure we could
You had
come up with some
something
numbers.
fine.
Mr.
Well,
Dresser, before you get to, just on that point, sorry, Justice Smith, but one thing leads to another sometimes. On that point is that, I lost my train of thought. You're lucky on that one.
Okay.
I just want to conclude with one final sentence. I know that's famous last words by a lawyer, but I think all of this then comes back to, again, kind of where I started in the beginning, with respect to the good faith. And I think with the law in flux, especially 3+ years ago, as it were, I don't see how this could really be considered to be bad faith or unreasonable under those circumstances. Maybe with the additional guidance as time goes on, we might look at this case differently, but I think in this current light, it is reasonable.
Thank you.
Thank you.
980, People versus Hickey. Mr. Keem's still with us. He's going, boy, this is another one of these.
So while recognizing the lack of preservation, we'd ask the court to look at our speedy trial issue in this case as well. Unless there are questions, knowing that his family is watching us, I'd like to talk about the sentence.
Go ahead.
Okay. So we assert that this incident is just not indicative of his character or his ability to be a productive member of society. You know, appellant has an alcohol problem, but he has several qualities that demonstrate that he could be a productive person. He cared for his brother, who's paralyzed from the neck down during his later teenage years. He genuinely accepted responsibility, including apologizing to Tim's family and Tim, the victim in the case. He still wants to be friends with appellant. He recognized that, you know, he wasn't really responsible for his actions. Appellant has a minimal criminal history here. And, you know, the incident happened after a 6-hour alcohol binge, and there was possibly an intoxication defense. There's possibly a justification defense. He didn't do that. He accepted responsibility. We assert that the 12-year term under such circumstances, though bargained for, was still excessive, and we'd ask this court to substitute the trial court's discretion with a sentence of its own. Unless there are questions about that, then we will rely on our brief.
I just have one question. I noticed that let me see if my microphone's on.
I can hear you.
I am, okay. That when the police officers came to the scene, he indicated that he had killed his friend with a shovel. And there was, first of all, he didn't kill his friend, and second of all, there was no shovel. Is that consistent with your recollection?
That is consistent, Your Honor. And it was so such a strange scene, and the only thing that I can chalk that up to is just how intoxicated he was at that time.
Right. He has no recollection of hours, including this incident, correct?
Correct, Your Honor.
Before and after. And the last thing, I think I had seen in the PSR that he had a family history of alcoholism. I think his father had been an alcoholic, and he indicated that he started drinking when he was age 13.
Age 13, that's correct, Your Honor. And he was doing well in rehab until COVID hit. They knocked him out of treatment early, and through this, you know, he obviously fell off the wagon here and really had a rough a rough day, but I just, we assert that it's just not indicative of the person that he actually is.
Thank you.
Counselor, excuse me, can you remind me of what the original offer was at the trial court?
The original offer, Your Honor, was, I apologize, I don't have that in front of me right now.
Okay, I thought it was 18 years, but I wasn't sure. Okay, but, okay, thank you.
Yep, I apologize.
Good morning. Josh Tonner on behalf of the people, and may it please the court. Judge Greenwood, I believe it was, I don't know if a firm number was discussed, but it was in the high double digits, I think 18 or 20 years. There was maybe a range, plus 5 years post-release supervision. The victim's feelings about the case were the reason why the people amended their plea offer to, and also I think the influence of alcohol in the events of the case were the reason why the people offered a plea down to an attempted assault in the first degree with that lesser sentence of 12 years plus 5 years post-release supervision. Just to clarify, Justice Nowak, I believe it was the defendant's call to 911 where he said, I killed my friend and decapitated him with a shovel. I think he said he cut his head off. When the police arrived, it's actually not clear what he told the police when Officer Burley arrived. What it was in the report was that when Officer Burley arrived and he said that, defendant was covered in blood but had no injuries of his own. The victim had significant lacerations to head and upper body, had a broken cheekbone, I believe another broken jaw. There was a crossbow bolt that was embedded in the floor, and Officer Burley believed the victim to be deceased when he went there. It was only when he started gasping for air. The PSR also bears out that with the defendant's prior arrest and conviction was a felony arrest reduced down to a criminal mischief that also involved the defendant not remembering what happened that led to his felony arrest. So I think the court was correct in saying that the defendant has a history of being very violent when he's intoxicated, even though there's that limited criminal history. And I think that a lot of what is cited by the court, or excuse me, by defense counsel or appellant counsel in this case, requesting a reduction in sentence was already considered by the people in the court. I think the sentence is appropriate. Just briefly with regard to the defendant's 30-30 motion, it's not really a 30-30 motion, it's a discovery violation motion that was forfeited by his guilty plea, but in any event, don't want to rehash the last case, but there's very clearly had not reached the 6-month limit for the people to declare readiness, even if that statement of readiness or certificate of discovery compliance were vacated by the court or found improper. The people were still well within time limits, and so we'd ask that the defendant's convictions and sentence be affirmed. Thank you.
Thank you. 981 in the matter of Adam M.C. Good morning.
Good morning. Can you not see me?
Can't see you.
I am on there.
There you go. Now we can see it. You're solo today.
I see that. If there's any, I'd like to start. If there's any questions, I'm happy to address them. Want to, draw the court's attention to family court, which is a civil, civil in nature. So I think the court came to the proper conclusion in granting that the Department of Human Services motion for summary judgment and then moving on to the dispositional phase of that, because the lower standard of mens rea is applicable in family court, which again is civil in nature. And the definition of child neglect focuses on the nature of the harm to the child, as opposed to putting the mental state of the parent as the primary consideration. If you focus mostly on the mental state of the parent, then you run the risk of defeating the statutory goals, which is to protect the child. and to protect the child from depraved parental conduct. And I think this case, and we don't need to go deep into the facts, although I'm happy to, is one of the most depraved that you can encounter, and has left Adam with lifelong trauma. I would also just like to note quickly that unification in this case is not possible. There is a no contact order of protection. That is not something that the attorney for the child has requested, even going forward, be changed. So even if Adam doesn't choose to be adopted, he is still with the foster family that's going to be his forever family. And if there's any other questions for the court, I'm happy to address them.
Thank you very much.
Thank you.
982 in the matter of Brandon P.
Good morning, Your Honors.
Wait just a minute. Okay, there we go. Go ahead.
Thank you. Good morning, Your Honors. Caitlin Connolly for the appellate.
Before you go any further, I have a question for you.
Yes, Your Honor.
Can you explain to me how the mother is an agreed party in this case?
Well, Your Honor, it's our position that the mother joined in the petitioner's petition, advocated in favor of the granting of the paternity, the DNA test, and is aggrieved.
However, she didn't make any motion for that, correct?
Well, her attorney, she testified on behalf of the petitioner, and her attorney filed a closing statement arguing for the granting of the petition. But she did not file her own petition. That is correct.
Okay.
Why shouldn't we follow matter of Tariq S. and the standard that was set there for whether or not a party is aggrieved?
Your Honor, just give me 1 second, please. I focus more on the second point of in preparation for this case.
I can catch up if it helps. I think the quote from Tariq S., a party is aggrieved, and either when they ask for relief, which the mother hasn't done, or when someone asks for relief against her, which I don't know if we have that, which the person opposes, we certainly don't have that, and the relief is granted in whole or in part, and we don't have that either. It seems like there's three factors and we have none of them.
Well, Your Honor, I would argue that the relief was granted against the mother because this is her child, and she's.
But again, however, she never formally joined in the petition that was dismissed. She didn't file her own petition. I'm really struggling with how she's even an aggrieved party to this and how she can even bring this appeal.
Again, I would just say on the grounds that she filed a closing statement advocating in behalf of the.
I don't think that's the same.
Okay. Well, thank you, Your Honor.
Okay, thank you.
Thank you, Your Honor.
Good morning.
May it please the court, Mary Hope Benedict for the child hunter. If the court has any questions, if the court determines the mother is not aggrieved, then I assume there will be an affirmance then, which is what we are asking for at this point, despite the fact that at the hearing, the AFC did support the DNA test. But at this point, we are asking that the court.
I'm not sure if it'd be an affirmance, it'd be a dismissal.
A dismissal, correct. I'm out of practice with that, Judge.
Okay, thank you both very much.
Thank you.
983 through 984 in the matter of Cameron R. Morning, we gotta wait for everybody else. Almost. We lost one. There we go. Okay, go ahead.
Good morning. Robert Gallimore. I'm the attorney for the appellant in this case. The appellant had 2 neglect findings in family court. one involving drug use and the other an unrelated failure to have the child have appropriate medical treatment. I think the problem with the substance abuse, there's two main problems with this. Is first, the court depended on the child testing positive for drugs at birth, and
As did the mother. Excuse me, Counselor, as did the mother, correct?
That's the allegation, yes. That they were positive. I think so. I think that's true. Yeah, I'm sure of the child, and I think that may be true as to the mother too. Yes. But the Court of Appeals has ruled that those findings in and of themselves are not neglect. This court has ruled that in Faith K that if there's additional problems, in that case the mother had a long history of neglect. Then that's something that's in play. But my client didn't have those problems. It was her first child, and there wasn't any proof put in that she had some ongoing prior history of problems. The other problem with the drug use finding is my client was in treatment the whole time. She
admitted herself that she was still using drugs.
She had admitted that she had relapsed, but I don't think the admission rises to the level. The department argues that Carter B, somebody they were using constantly, and there was just no cessation in use. But my client, by the admissible proof, really only admitted that she relapsed, and she said that to a couple of people, but she didn't admit that she was using constantly, that she was using around the child, that it was ongoing. She had a relapse. I mean, people who are in treatment, sometimes they relapse. I don't think we want to get into the position where we want people to not come forward with the.
Well, we'll look at that. We'll look at that part. Why don't you go on to the second part?
Okay. Yes. Thanks. So the court found that my client had also been neglectful in getting medical treatment for the child. She dropped the child and took the child to the hospital the next day.
But she waited to take the child to the hospital until this child started having seizures, etc. She didn't even inform anybody that the child had fallen on his head.
She did. She told her mother that the child had fallen, and admittedly she didn't tell the mother how the child fell. She dropped the child, and I think she said to her mother the child fell off a changing table or something. But she had told her mother the child had fallen. She had watched the child and been aware of what was going on. She had I think she looked up on something on WebMD too, and she didn't see anything that rose to the level of concern until the next day, and then she promptly took the child, and the child got treatment. I think this is a similar situation to McKinley, where there just wasn't proof that even though this may not have been the most ideal care, that this in and of itself, that the child fell, and that there was I think it was 24 hours or less before the child was brought in, that this rises to the level of neglect.
Okay. Thank you.
Yeah, thank you, Anna.
Amy Hollenbeck on behalf of the department. The department's position, obviously, is that both findings of neglect were appropriately supported by the evidence. In regard to the drug usage, our position is that the child being born drug addicted, her admission to one of the caseworkers that she was using prior to that was sufficient to establish prima facie, and also in conjunction with the other evidence offered by the Helio health counselor and the other social services people of her use over the period of time prior to and after the child's birth. That was sufficient for prima facie, and that her treatment, although she went fairly regularly, didn't miss an unusual number of sessions, could stand to override that prima facie finding. In this case, the number of relapses, the type of relapses that she had were indicative of noncompliance. She relapsed, I think it was 3 weeks after the birth of this child. She then relapsed again around the time that the incident, shortly after the incident occurred with the child being dropped. And to the level that her outpatient treatment provider said that she should attend inpatient treatment and suspended her from the outpatient treatment program. So I would submit that and that was the only evidence, because she chose not to testify. She chose not to present any other testimony concerning her efforts to rehabilitate herself. So in the best interest of the child, we feel the court was appropriate to find neglect on that basis. Then the next basis would be the incident involving dropping the child. My recollection of the record, and perhaps I missed something, was that what she told her mother was that she dropped the baby bottle. And it's a fine line when the child is dropped, but he was dropped onto a hardwood floor. He was less than 3 months old. I would submit that it would be appropriate at that point for a reasonable and prudent parent to seek some medical advice. She did look online and she had some training herself. However, she then proceeded, as Justice Smith has pointed out, to leave the child with her mother. And my recollection of the testimony was without her mother's knowledge as to what had happened, so that even if that was somehow appropriate for her mother to watch the child, her mother was doing so without any knowledge of the incident. And that combined situation created a danger of serious injury to the child. And again, there was nothing brought forth by the defense to refute that. The finding was, I would submit that the court soundly based its finding of neglect on that.
Thank you.
And unless there are further questions, that's all.
Thank you.
Your Honors, I'm Scott Otis. I wasn't at the trial on this matter, but I was assigned on appeal. Page 19 of the record and other places suggest that the mother, after dropping her baby on the floor, told the maternal grandmother that she had merely dropped the bottle on the baby while feeding the baby again. And the next day left the child home alone for some time with the mother, unaware why the child had fevers, why the child was so fussy, until finally why the child had a temperature and why the child was so fussy, until the child finally began to have seizures. The record suggests it was 30 hours later when the infant was finally taken to the hospital, where a skull fracture was shown on diagnostic imaging. It was only then that she finally admitted to the hospital and the mother that she had dropped again the baby. And the timeline of her positive tests suggest that it was likely pursuant to relapse, although the judge declined to make that specific finding. Or rely on the medical evidence at all that appellant finds so objectionable. Rather, the judge correctly, I think, purported to rely on the mother's own admissions throughout to various people, and the mother's refusal or decision not to testify in her own defense. I'll rely on my brief regarding those points if you have no other questions, and I'd ask you to affirm in all respects.
Thank you. 985, in the matter of Clarissa F., William F., and Elena F., and Ayla O.
Okay, we are.
Wait just a minute, we gotta wait for a couple other people. One of them. Do we know what's going on? There we go. One more person. Oops, lost one.
She's back.
Morning, we need one more person.
Your Honor, he is in, but we're waiting for him to turn his video on.
Is he aware he needs to turn his video on?
I'm having a problem getting my video on. I don't know why it's not going on. Keep clicking in it and it's not working. Can you still hear me?
Yes, we can hear you.
Okay.
Can you see us?
I can see you. I just can't. It won't unclick. The video won't unclick.
What?
It won't start. I keep pressing it and it's stuck, I guess.
So is everybody okay? He can see us and we can hear him? Okay. Go ahead. Go ahead, Miss. Okay, you don't have to keep kicking. Mr. Pajak, do you want to go ahead?
I really don't have anything to add to my brief. I ask for an affirmance in all respects.
Thank you. Mr. Broderick?
Yes, may it please the court. I can rely on my brief. I just would emphasize that my client is really upset about the order of protection. That is his big thing. This is a person that he has as a father figure, and he's being forced, even at 17 years old, not to have any contact with him. So with that, I will rely on the legal arguments in the brief.
Thank you. Ms. Maraca?
Your Honors, thank you. May it please the court. I certainly will also rely on my brief. That being said, my client is the one biological child of the appellant respondent, but the underlying issues brought up in the appeal, I would ask that the court grant the relief requested in my appeal.
Thank you. Number 986 to 987. We just did that, so I'm sorry. No, we didn't. Oh, I'm sorry.
Stevens.
986 and 987 has been settled. Okay. 988, Carberry Cove versus Town of Henrietta Board of Assessment. Good morning.
Good morning. May it please the court. My name is Peter Weissar from McConville, Considine, Kuhlman, and Morin, and we represent the appellant Town of Henrietta parties. This is an appeal following a judgment after trial for consolidated tax assessment review proceedings. The subject properties are 70 single-family townhomes on separate subdivided lots, and they're owned by the developer and offered for rent. The parties have no dispute on the law, which requires the properties to be valued in their use. The subject properties must be valued with reference to their existing use without regard to future potentialities or possibilities, and may not be assessed on the basis of some use contemplated in the future. The crux of this case, the issue that is in dispute, is what is the use of the subject properties. The trial court found that the subject properties are a multifamily development on a single parcel, and then proceeded to value them using a comparative sales approach, comparing them to another apartment complex, and then concluded that the value on a per unit basis was roughly $155,000 for each completed unit versus an assessed value of over $188,000. The town contends that the court failed to give conflicting evidence the relative weight it should have, and erroneously concluded that the separately subdivided single-family homes should be considered multifamily rental property on a single parcel, even though such a use is prohibited by the zoning.
With respect to Mr. Rubino's report, And when he compared the homes, the first part of his report, where he compared the homes to other single-family homes, did the single-family homes that he used as comparables, did those have a shared firewall, and did they have the same insufficient setbacks and the cluster provisions that this complex did? Or was he comparing apples to oranges?
No, he was comparing apples to apples because they are townhomes. A townhome is they have 0 setbacks, so they would have a shared party wall. They would be on separately subdivided lots, and so he compared them to single-family homes. The clustering provision that you mentioned, so the cluster, when you do a cluster subdivision, the way it works is you take, in this case, it was of over 72 acres. You figure out what's the maximum density that you could construct using the conventional zoning. You figure out that density, and then you can preserve open space. You can reduce the size of lots. You can reduce the setbacks, which is what they did here. But it doesn't change the use. The use is still a single-family home.
No, I appreciate that, but I'm just trying to picture that if I'm looking for a home of, 1,500 square feet or 1,400, roughly these size homes, and I'm choosing between a single-family home with a yard by itself on its own on a regular street, as opposed to a situation like this with a shared wall, would I be looking at the same properties?
You would
or wouldn't I be looking at very different
No,
properties?
you would be, Your Honor, because these properties are on their own individual lots.
No, it's on its own individual tax lot, but my neighbor's right there.
Well, but that's how a townhome works. There's each of these.
Not always.
In this case, this is how the townhome works because.
So you sound like it was in general.
I'm sorry?
You sound like it was in general, your comment.
So these properties are townhomes. They are townhomes that are on separately subdivided lots. It's not merely a tax parcel, they're subdivided. Once the subdivision map is filed in the county clerk's office, these lots are created. That allows them to construct the properties. Each townhome is on its own lot. It has a private driveway. It has a private garage. It has its own yard. There are no common area or other amenities that you would expect with an apartment complex. There's no. These are on public streets. There's 2 streets involved. Like I think 56 of the townhomes are on Fall Creek Trail, and the other, I may be getting the names mixed up, but then they're on Coventry Cove is the other 14. Some of them have walkout basements. They have firewalls because there's 0 lot line. They have 0 lot line construction, but under the code, they are individual single-family dwellings.
I understand under the code. I'm asking if Mr. Rubino's comparables, if those also had firewalls.
I believe they did.
You believe, or isn't that real important? Because whether a house is sitting on its own or whether it has a firewall with a neighbor, a person that you don't know that you have to live with, that which feels, of course, more like apartment living, if Mr. Rubino didn't provide any comps with properties with the same firewall, then again, it comes back to, isn't it apples and oranges?
I don't have that part of the record with me here.
Okay.
We believe I believe, my recollection is that they were all townhomes, and I believe that they were ranch-style townhomes, which typically would be connected to another. I don't know of a definition of a townhome that isn't connected to another adjoining
Unlike a
structure.
townhome, there's no homeowners association here, right?
I disagree with the premise of that question when you say unlike a townhome. There is no
Generally a
requirement to
townhome.
have a town. In the record, there's no requirement that there be a homeowners association here. They're on subdivided lots. You could go and sell them today. There's nothing required for conversion. In other words, the mortgage already contemplates that you could sell each individual lot. It might be advisable to have a HOA, but it's not a legal requirement to have that happen.
Okay, we'll look at that.
Okay? And so, the crux of the issue is really whether these are an apartment on one parcel
No question.
or on,
We get the crux of the
and we also think, as you alluded to, single-family homes are typically appraised using a comparative sales approach. And the only evidence in the record that compares townhomes to townhomes is what the town presented through Mr. Rubino's testimony and appraisal report. And based on that, unless the court has further questions, we request the court to reverse the judgment of the trial court and dismiss the petitions.
Thank you.
Robert Jacobson for the respondent. Good morning. The key here is, how is the property being used? It could be converted or changed to something else, but the rule of law for assessment cases is current use. And in this case, these properties are 70 townhouses with 35 buildings and a common wall, and they're owned by one person, and he rents them out to basically empty nesters. They're nice properties, and they're like they're nice properties and they're good to live in, but they're still rental properties, and that's how they should be valued. If you value them as single-family houses, where people buy houses separately and they pay a lot of money because they want to own the property, then you're going to add $500 a month to the taxes, and they're not going to be able to keep this property going. They're not going to be able to charge $500 extra in rent. They're going to probably have to terminate it. It'll take 2 years because they've got leases.
We don't even have to go through all that.
Okay. The two arguments that are made in the respondent's reply brief, one is they're ready to be sold off, and they could be sold off with some additional things that I mentioned in my brief. The problem is
that could change the whole.
That would change the use, but they haven't been sold off yet. And he also argues that they violate zoning, but they don't. Zoning allows two-family buildings or less, whereas the statute doesn't like traditional garden apartments in an R1 zone. It specifically defines the prohibited apartments only being three-family units or more.
Mr. Jacobson, may I ask you a question?
Yes.
How does the owner manage this property? Does he provide the maintenance services and that type of thing, or is this just a pure rental and the renters do everything? How does that work here?
The renters only take care of the interior, just like an apartment complex. The only difference between anything else that was ever raised is that the town plows the driveways. Not the driveways, the town plows the roads, but the owner.
I thought that was pretty generous of them. They plow their driveways.
My client does all the other maintenance, repairs, and plowing the driveways and whatnot, for the most part.
So your position is it's run similar to a garden apartment complex, is that?
It's run the same way, but the area doesn't want garden apartments here, but they don't mind having two-family rentals. And there's two cases that are important. The Hampshire Rec case says a golf course should be valued as a golf course, even though it was bought for twice as much money to be used as to do a development. But the other case here that really has never been mentioned by the respondent are the drugstore cases, which were my cases. In those cases, they said if a property is being used as a drugstore, then you have to value it only comparing it to drugstores. In this case, if the property's a townhouse rental community, you have to value it comparing it to townhouse rental communities. It's the same argument. Even though in the drugstore cases, the other appraiser said, well, no, I want to value it like a dollar store because it's a similar retail property. The court goes, no, we look at the use. The use is a drugstore. You got to use it you got to value it as a drugstore. And here the use is a rental community. You got to value it as a rental community. If you adopt the respondent's position, think about the consequences. For example, in New York State, you can make the same argument that all townhouses, if they're similarly situated, should be valued that way because they could all be sold off. Sometimes they just have to apply for its paperwork to be able to sell off the units. Well, that'll change the assessment on all townhouses, and who's going to pay the extra rent because the taxes are going to go up.
We got that.
Okay, you got that. It would change New York City properties that are, and the last thing I will talk about that was mentioned on their direct is the method evaluation. In my opinion, this property is an income-producing property. It should be valued using the income approach. That's exactly what our appraiser did. I don't know what the judge really he had both methods, the sales method and the income method to look at, and he mentioned them in his decision. But I think the income approach is a better method, even though it's lower than the court's decision. And if you want to, and the next best method would be the sales approach. We used apartment complexes. We couldn't find any other, neither appraiser found any other townhouse rental projects exactly like this, so we went to the next best thing, garden apartment or typical apartment projects.
Well, Mr. Jacobson, well, we may agree with you that perhaps the income method should have been considered by the court. You didn't cross appeal on that issue.
No, I didn't, but if you want to lower it, I'd be okay with it.
Thank you. 989, 2006905 Ontario Inc. versus Goodrich Aerospace Canada Ltd.
I was wondering if you wanted the same thing. I was still over it, okay.
Okay.
Good morning, Your Honor. May it please the court, my name is Joseph Zadarsky. I represent the plaintiff appellate in this case. And it's a 2-week jury trial and a very complicated case. Probably 350 exhibits were entered into evidence. I'm going to try to boil it down to the 3 essential points which I think this court needs to address and which we rely on in our request that the decision below be reversed. The gist of our case, of course, was that the plaintiff was a supplier of aircraft landing gear bushings to the defendant. They had a long-term relationship, about 10 years.
We know all that.
I know that, but I just wanted to set the stage for what I'm dealing with here, because the first issue that was decided, which we think is the probably the most important issue, is whether the decision of the jury was against the weight of the evidence. We had moved to set aside the verdict and for a new trial based on that, and the trial judge denied that motion. We submit that that's error. And here's why. The first question in a fraud case is whether a representation of a material fact had been made. The gist of our case was that they had represented to us in their words and actions that they intended to negotiate toward a new agreement, which would have been another in a series of agreements that we had to continue our relationship. The trial judge found that, well, it's a matter of credibility. Mr. Sauve, the defendant, he said that he told the plaintiff that after the 2014 negotiations were over, that was going to be the last agreement.
The jury heard all this, and
Right.
the jury
And
decided, the jury is the one that gave credence to the other sides.
Right, and the jury heard his testimony, and the jury heard Mr. Glegg's testimony, and decided it, and the judge said, well, they believed Mr. Sauve, and that's the end of it. The problem with that is that there are 3 exhibits that were in the record that make it very clear that they did represent.
Did the jury have those exhibits?
I have those exhibits,
No,
and I'll
the
tell you
jury
what they
had-
are.
No, the jury had the exhibits as well. And so the jury saw that, and they made their decision on what they heard in the courtroom and the exhibits, correct?
Of course, they had the exhibits, but our contention is that they either didn't understand or misinterpreted the exhibits, but that when you examine the totality of the evidence that was presented, that there is no way that for them to find, fairly interpreting all the evidence, that there wasn't a representation made.
Okay, well, we have all that, so we'll look at that and
Okay.
look at that very carefully.
The second point, which I think is equally as important, is that we contend that the trial judge abused his discretion when he granted a motion in limine which prohibited us from cross-examining defendant Sauve about his prior bad acts.
That the judge did allow you to cross-examine him on, and I believe that the ones that didn't, one happened 23 years prior to this happening, and it was right after he got out of college, et cetera, correct? That
It was
first-
22 or 23 years before. I don't know how long it was after he got out of college, but it was him
Apparently it was right
forging
after
a
he got out of
signature to a document, which would be a criminal act, and I think the case law is very clear in New York
But
that
this
there's
was-
no cutoff date.
Okay, but this was, what I'm saying, it was within the judge's discretion, and did the judge abuse his discretion in doing that? And that's something we'll have to look at.
Yeah, well, that's our contention, that since the case law says that there is no cutoff date for criminal bad acts,
I agree.
for
there's
him
no
to decide it
cutoff,
that
but
way
it's
was an
within the
abuse of
of
discretion.
the judge.
I'm sorry?
But it's within the discretion of the judge.
Of course, that's the whole question that we're arguing here. He abused his discretion when he made that decision. I think that from the perspective of lawyers who have tried cases for a long time, I've never heard of a criminal type bad act being prohibited in cross-examination. I submit that it was a clear abuse of discretion.
And the second item was misuse of a credit card, and that wasn't as severe, but it was right at around the time that all of these events are taking
Yeah, that was more timely. It wasn't 20 years before. There was an audit done.
Investigation into that, and they found that there was no abuse, correct?
His employer found that these irregularities did not amount to a reason to terminate him, I think was the, but I have the audit report here. It was submitted on the motion in limine. And what the report concluded was that Sauvé used the card for personal uses, purchase of shoes in Italy, and expensed the charges to the company. Charged 2 hotel expenses for the same night.
We've got that, we have that.
Well, I think that these are important improper acts that he committed that we should have been able to ask him about. The jury is entitled to know if the witness is a habitual liar, if he's engaged in deceit, if he's dishonest. And Judge, I remember back in my youth when my grandmother used to say that you can always tell when somebody is an honest man by what he does when no one is looking. And when no one was looking at Mr. Sauvé, he was taking liberties with his credit card and stealing from the company. And whether they fired him or not for that, that's something we couldn't prove. But the fact of the matter is we should have been able to cross-examine him. The jury was entitled to know that this man, when
We'll look at
the
that
chips
later.
are down, will shave the truth. And that's a key fact. All right. The last issue that I'd like to discuss is the fact that back at the very beginning of the case, a motion to dismiss had been made, and 2 of our causes of action were dismissed by Judge Chimes when she was in the commercial division. That was negligent misrepresentation and fraudulent concealment. And her basis for doing that was that there was no special relationship between the 2 parties. And we contend that based on that was a motion, by the way, based on the pleadings at the pleading stage when we were entitled to have all of our allegations in the complaint treated as true and all favorable inferences resolved in our favor. And the parties at that time, we alleged, had an 11-year relationship, had signed a series of contracts, that we were responsible for 50% of the plaintiff's purchases of bushings for landing gear construction, and they supplied 50% of our revenues, and we supplied them with 65% of their needs.
Wasn't there a situation, discrepancy or dispute concerning those that consequential damages caused, that your
Right.
client was unwilling to go forward with that?
Yes, there was. In 2014, the parties were negotiating the next 2 years agreement that was going to take effect in 2015 and 2016. And there had been a transaction where United Technologies was involved in a corporate transaction where a new owner controlled the business. The new owner, I think it was Raytheon, introduced a provision where they said they wanted all contracts to have a clause where the supplier agreed to be responsible for consequential damages without limit. My client wouldn't agree to that. There was a tough back and forth negotiation, and eventually they agreed to put a $750,000 cap on his responsibility for consequential damages. You can well imagine in the aircraft landing gear business, if there was a crash or a malfunction, whatever, the consequential damages could be very significant. My client didn't want to be responsible for it. When that happened, they decided, we're done with these people. We're going to exit from them when this 2-year contract is over. But they never told us. They kept it a secret. Instead, they pretended to negotiate the new agreement. And they did it for...
That's what we're going to have to look at that very
You have
carefully,
that.
and we
But
understand all
just to
that.
answer his question, that was the business about the consequential damages. And so our view was everything's a negotiation. I think Mr. Sauvé even testified that everything is a negotiation. At the very end of the deal, we were told to redline documents, and there was going to be a back and forth.
I'm going to ask that you listen to me as well, okay? And then we understand all that, and we have all of that in front of us, so we know what happened here and what was alleged to have happened.
Okay. Well, I think that unless you have any other questions about the case, that's the substance of my argument.
Thank you.
Thank you.
Good morning, Your Honors. John Soretta for the defendants' respondents.
Now, I want to hear what you have to say about this. It does seem that they led them on, that they had meetings with them, that they redlined drafts of the new contract, et cetera, and no one ever said to them, we have absolutely no intention of dealing with you anymore.
So the evidence showed, and the jury heard, as did the presiding judge, that they were not leading them on. So the question that went to the jury on the jury interrogatory was there a representation of an intent to negotiate in good faith? And where the issue was joined between the parties was that our witnesses and our evidence and our documents showed that we had no intent to negotiate a new long-term agreement unless, as Justice Walker notes repeatedly in the post-verdict motions, unless they will relent and back off this cap on consequential damages. So there is testimony all the way back to 2014 at the time of the negotiation of the new long-term agreement, where Mr. Suave is very clear with Mr. Glegg. He says, look, if you are going to insist on this cap, we're not going to do a 5-year deal. We're only going to do a 2-year deal, and the contract is a 2-year deal.
But they're having these lunches, the 2 lunches, they're having these meetings, they're asking for red line drafts of potential agreements, potential long-term agreements. And then we see this July 14th email. Between us, I have been tying up 2 sources. And you get that as the start of it. How could the jury have reasonably considered that email? How could the jury have disregarded it, maybe, is a better question.
I don't think the jury did disregard it, because Mr. Suave testified about this document. It's that he had told Mr. Glegg at the lunch, the June 30 lunch, that, look, whatever we're going to do, as I have told you repeatedly throughout all these many months, whoever's going to get this business going forward is going to have to agree to a cap on consequential damages. And what Mr. Suave testified to was, I very much wanted their best and final in June and July and August. I wanted their best and final because I wanted it to go into this passport process.
But Mr. Sauvé in the July 14th email didn't say, I'm trying to get their best and final. He said, between us, I'm tying them up.
So
different characterization, isn't it?
It is a different characterization. So you could, that might have been relevant as on a scienter issue, or that is sort of internal communication as to Mr. Suave's state of mind. But Mr. Suave testified that all he meant by that was that I want to get their proposal so we can include this in the passport process. And Mr. Suave testified, and again, the jury had every right to believe this because it's consistent with his other emails, that he thought that Two Source had a good chance of keeping this business if they would just give up on the consequential damages. And I just want to take a little broader perspective on the evidence, if I could, in my time up here, because going back, so December 2014, then June of 2015. And again, this is not just testimony. There are emails that show this. Mr. Suave has a face-to-face with Glegg and says, look, as we said, we're going through a quotation process. You've been labeled an exit. Mr. Suave testified you've been labeled an exit. You're in a passport process. I just want you to know all of your work is being quoted out competitively to other suppliers. Trial exhibit, I think it's 145. It's definitely 2260 in the record.
As I said, like, the jury heard all this. The jury knew all this when they made their decision.
They absolutely did, Your Honor. I was just trying to address Justice Nowak's questions, but one small point further on those documents is that even if, because there's two elements embedded in the jury interrogatory, so the jury very well could have, and there would have been a very substantial basis in the evidence to find, well, any representations that were made are not material. Because again, we're talking about a 2-year contract. There are two sources on notice that it's only getting a 2-year contract. It knows there's no automatic renewal. There's not even anything in the contract requiring notice of termination. And so the jury very well could have, and there would be a very strong basis, as a matter of fact, to say, well, these are really sophisticated entities, bargaining hard. They know that, saying send red lines is not any guarantee of future business. That's not a material representation of anything. And that would have been a perfectly appropriate finding of fact as the post-verdict, the ruling on the post-verdict motions indicated.
We'll look at that very carefully.
I appreciate it. Thank you, Your Honor. I would like to go to the evidentiary issues because I want to respond to a couple of the things that were said about them. The first, on the prior bad act from the late 1990s, 23 years old, that's just a discretionary determination. And I just, with the court's indulgence, there are cases, a lot of cases. This court's case in People versus Tice that say a 13-year-old conviction of forgery in a criminal court can be too remote in time. So there are cases.
It doesn't even have to, again, it's within the discretion of the judge anyway, so there's no, hard-line rule here that so many years pass and then you can't use it. It's the discretionary.
That's absolutely right. And the other thing I'll just briefly say, because it was discussed at some length, are the investigations. At 33 of the record, in the opinion, it's right there. The internal finding of that investigation was that there was no fraudulent behavior by the defendant. So as a gatekeeping function within the court's discretion to say, there's just not any basis, this is not probative enough, this isn't going to moral turpitude, and it's going to be a waste of time.
Certainly you're saying it was not an abuse of discretion.
I am saying that, Your Honor, yes. And very briefly, before I sit down, unless the court has questions on the fraudulent concealment and negligent misrepresentation claims, there are a lot of cases, we cite them. Hard bargaining at arm's length between parties, which is actually alleged in the complaint in this case, is just inconsistent with what is described in the brief as a co-fiduciary or special relationship. This isn't a co-fiduciary relationship. This was arm's length bargaining between very sophisticated parties. Justice Chimes was acted entirely appropriately in dismissing those claims at the outset. Unless the court has further questions, thank you very much.
Thank you. 990 Galbun versus Faxon St. Luke's Healthcare.
Okay. Good morning, Your Honors. May it please the court. Andrew Borelli on behalf of Faxon St. Luke's Healthcare. First point I'd like to address is the initial burden issue. Defendants absolutely met their initial burden on the storm in progress doctrine here. There is a plethora of evidence, which I won't walk through every piece, but significant objective evidence, including the Doppler data, as well as the video surveillance, that unequivocally demonstrate that there was precipitation and freezing rain at the time of, on the day of Ms. Bunn's fall, both before, during, and after her fall. And in that regard, and for that reason, based on that data and Mr. Mahar's affidavit, we believe that the hospital met its initial burden. Now, I know the plaintiff takes umbrage with the fact that Ms. Bunn herself testified.
And that was attached to your motion papers, correct?
It was indeed, Your Honor.
So in carrying your burden, we would have to presume that vis-a-vis what Ms. Bunn said in her deposition was true for purposes of this motion, correct?
Correct, Your Honor, and I don't dispute that. But I would say in reference to the Gould case from this court, that at most that establishes that there may have been a lull or break in the storm at the time she fell.
Right. So, but how do you, given that testimony, how do you establish on your motion, as a matter of law, that there was a storm of progress that suspended your duty to maintain this premises in a reasonable repair?
Well, one, it's contradicted by the objective evidence, and two, in light of the Gould case, that dealt with an initial burden.
You say it's contradicted by, so your own motion papers put in contradictory evidence?
No, well, Your Honor, I'm saying that the objective evidence is what is controlling here. But even if we accept that that is true, as Your Honor wishes, the Gould case was an initial burden case.
Don't say as Your Honor wishes.
Well, I'm sorry, as Your Honor said.
There's a lot of things I wish. They're not going to.
I apologize. As Your Honor suggested to me, or asked me.
But seriously, I don't mean to make light of your argument because it's a serious case and you put a lot of effort into this. But what I'm sort of stuck on is the case law that says that we are to look at the proof in the most favorable light for the plaintiff here on this motion for summary judgment. And when you attach your deposition transcript, that seems to say it was kind of, and I'm paraphrasing, I realize it was kind of raining before, and then I didn't notice the freezing rain until the ambulance was on its way. If we take all that as true, that is in the most favorable light, then I agree with you, there's probably contradictory evidence in your motion papers, but doesn't contradictory evidence in your motion papers mean question of fact?
Not here, because the rule in Gould, which was an initial burden case, there was a very similar case, storm in progress. This court in 2021 determined that the defendants met their initial burden with meteorology evidence and also submitted the deposition testimony of the plaintiff, indicating that it was not precipitating at the time of the fall. And this court concluded that at most, that established a lull or break in the storm, which, and not a complete cessation of the storm, and therefore the duty of the hospital or the property owner to maintain the premises in a reasonably safe manner hadn't started back up. It remained suspended. And so that's what I would argue here, that this is nothing more than a lull in the storm, because the evidence is undisputed that it rained afterwards. It was raining while she was on the ground, and it's undisputed by even Ms. Bunn, who she also testified that there was a mix, I think, or a rainy, freezy mix in the morning well before her fall. So this is clearly a lull at most, and therefore we meet our initial burden, and the burden shifts to the plaintiff to raise a triable issue of fact.
We'll look at that.
Yeah. And then the second point I would just make is that assuming the court reaches the shifted burden analysis, the plaintiff does not take issue with the meteorology evidence, but instead focuses on the exacerbation issue and whether any remedial efforts exacerbated the slippery conditions that existed on the day of the fall. And the answer is no. Based on our meteorologist's position, there was going to be ice on that ground that she was going to slip on regardless of whether salt was laid or not. Additionally, Mr. Allen's affidavit, that's plaintiff's purported expert in opposition to our motion, his opinions are speculative and conclusory. He does not say that any use of this salt created additional ice or created ice that otherwise would not have existed at the time of the fall. His opinions do not address, although they conclusorily state that calcium chloride would have been a more effective de-icer, he doesn't state at what temperature the rock salt becomes ineffective, how much rock salt has to be laid to be ineffective, how much precipitation needs to fall to dilute the rock salt solution to be ineffective. None of that is stated anywhere. And so to the extent this court reaches that shifted burden, it should conclude, as the trial court did, that Mr. Allen's affidavit is speculative and conclusory. And unless the court has any other questions, I'd rest on my papers.
Thank you.
Thank you very much.
Please, the court. I'm Anthony Murad on behalf of the plaintiff respondent, appellant Gail Bunn. Clearly, there's a question of fact whether or not there was a storm in progress. And Gail Bunn, who was going into this hospital, who was diagnosed with cancer, was expected to be a safe place for her to transverse over. She says when she got there, it was not snowing, it wasn't precipitating, and she put her sneakers on and walked, and she fell. The interesting point, which was not mentioned, there was another lady named Bonnie Steele who gave an affidavit, who said, I took my father to the same hospital. I arrived there at 11:47 p.m. Plaintiff's accident is 1:30 p.m.
You mean AM?
I'm sorry. And when I arrived there, it wasn't precipitating, it wasn't snowing, it was icy. And when I came out and I fell, it wasn't precipitating, it wasn't snowing, and it was still ice on the ground. In fact, there was a mention that the snow contractor was there and some of the machines were broken. So clearly, there is a question of fact if you have the plaintiff saying it wasn't raining or snowing. So that's that question. And the second question is, and I guess I can address that as well, whether or not, assuming there was a storm in progress, did they create the condition and make it worse? There was a contract that was entered into between the parties that says specifically calcium chloride to be used on sidewalks. That was a contract between these two parties that entered into. Why do they, and they highlight calcium chloride on sidewalks. Why do they do that?
State, because we're.
Oh, I'm sorry, I'm going back and forth, I talk with my hands. So there was a contract that said calcium chloride. They deviated from that, and the hospital, the contractor says, well, the hospital made that decision. So here it is, they're using the wrong substance. The hospital says that if we believe that there was a storm in progress, the hospital says people are coming in there and complaining that it's getting icy out there. They go out and they have a handful of rock salt, because that's what they only had on hand, and threw it out on the ground.
That was the hospital employees.
Hospital employee. Contractor says, when we do it by a way of a truck, right? So they're evenly spread. So
The hospital and the contractor shared the responsibility.
No question about it. No question about it. But there was an issue that where you got to somebody else, I think Dave Siriano says, well, the security guard, we don't maintain that area. So there's a question of fact on that. But anyway, they're out there applying rock salt when it's getting worse. Rock salt's not the substance. They're throwing it down. Did they throw it properly down? I don't know that question. The truck says, they say we do it by way of a truck that's evenly spread.
You've
All right.
explained it.
Okay, so.
You've cross-appealed here, too.
I
right?
cross-appealed.
And that's vis-a-vis the contractor, do I have that right?
Vis-a-vis the contractor, the Espinel.
You see, I've already touched on the subject matter of entirely displaced. I'm not so sure that's your strongest argument, respectfully.
Right.
But talk about the launching of an instrument of harm.
Yes,
here.
I'm going to talk about, again, we go back to the contract, right? The contract says that the contractor is supposed to use a sodium chloride or calcium chloride, which was the rock salt. And here's this question, and we asked for the spoliation too. They're supposed to be there.
There was a pretty big flood, wasn't there?
That's what they say.
No, I took the spoliation. Let's stay on launching of the
All right,
instrument of
launching of the force.
So as I understand it, you're relying on that, and I was on it, so I'm going to mispronounce it nevertheless.
Yeah.
Burgout case?
Yes.
Having to do with the healthcare center.
The Burgout, the Belmonte case.
And we know that the basic rule is you can't make it worse, right?
Well, I don't know about that.
What I mean by that is, by making it worse, you launch an instrument of harm.
Right, that's the whole law.
By failing to make it safer, you don't.
True.
Where does this fit and why?
Well, they made it worse because they created and exasperated any condition that was existing. The contract called, now our expert, whether or not, and there's questions, well, he says this, he says that, that's for credibility. The expert, who is a person that is familiar, who's involved, was involved with the Olympics, he's a snow expert, and he basically says that applying the wrong substance, and he explained in his affidavit, in his report, the difference between what sodium chloride does, which is calcium, right, what that does, versus rock salt.
He says that when you put rock salt down, which they did, again, the contract called for something else. What happens, it doesn't melt anything. So it stays on the ground. And then when rain hits it, which accordingly, presumably it did, it makes it ice. Versus the calcium chloride, which completely generates the heat and will not form an ice. So the expert is saying by using the wrong substance, this rock salt, and it came on top of the ice, which presumably was there at some point before, and when the rain hits it, it forms a brine. It keeps it water, and then when the temperature gets colder, it actually freezes it. So going back to your question, is they launched that force because
we'll look at that.
they used the wrong substance.
We'll look at
So that's the argument that we're making onto that. And also, we had the spoliation issue. That was basically because the contractor says, well, I'm there every day. Well, you know.
Spoliation, was it their fault that everything got flooded out and they lost his records?
I agree, maybe it wasn't their fault and everything, but isn't there a duty when they know there's 2 accidents involving 2 people that particular day? There was a letter from the claims adjuster from the hospital saying, hey, there's 2 accidents there. You know, turn it over to your insurance company.
But this isn't a critical piece of your evidence.
No, that's not the critical piece,
You're not looking
but.
to dismiss the case. It's a question of, you might even be in a position at trial, should you get there, to ask the court, hey, Judge, we want an adverse inference on that.
Exactly, but.
That ball is still in the air, so to speak, right?
It is, but if the argument is, well, we didn't get there until 1:45 that day, because that's when the snowstorm started. However, the testimony was, we get there every day. We mark down in our notes what we do.
Okay, we have that.
All right, well, then I rest on the rest of my brief. Thank you.
Good morning. Evan Rossi on behalf of defendant respondent Fairbrother Property Maintenance, LLC.
You would say that you didn't launch an instrument of harm and that you didn't entirely displace the owner's responsibility. That's the basic point.
Absolutely. But before I would say that, I would endorse the remarks of co-defendant Faxton's counsel that there's significant overwhelming evidence of a severe freezing rainstorm in progress for 4 hours from 11 a.m. to 3 p.m. on January 17th, 2017.
But if you're right on the first 2 points, none of that matters, correct?
That's correct. But this was an extreme storm that reached the 10th level of intensity, the red level of intensity on those Doppler images.
And we're going to look at all that.
It is a very severe, any indication by the plaintiff that this was some sort of on and off storm, it's an imaginary narrative. We have the surveillance videos, and I've been arguing for 3 or 4 years. This has been going on since 2017. I've been arguing at the Supreme Court, and now the Fourth Department, that the water streaking across the lens is from the freezing rainstorm in progress. There's also cars driving around with their windshield wipers on, showing that it's raining. So why are those cars driving around with their windshield wipers if it's not raining? And regarding the Gould case that Mr. Borelli cited, that case specifically gives the court the authority to look at a plaintiff who says, it wasn't raining when I got there, and say, well, okay, we have objective, scientific, blue ribbon, CPLR admissible weather records, along with a knowledgeable, experienced meteorologist. The plaintiffs didn't have any.
So you echo the Faxton's arguments?
Absolutely. Okay, we got
As to the moving forward to the force of harm, launching the force of harm issue, which was the Espinal exception most vociferously pled by.
You didn't make it worse.
We definitely didn't make it worse.
You did what you were supposed to do to the extent that you could do it.
Absolutely, and counsel said we didn't get there till 1:45. The logbook says we were there at 12:45. The incident report says we were already there when she fell. There were 3 separate falls, 3 separate sidewalks. My client put 9 tons of salt down.
Okay, you're just saying you didn't make it worse.
He definitely didn't make it worse, and that's the Church versus Callanan case. Somebody was supposed to replace 280 feet of a guardrail and extend an additional 40 feet, and they only replaced it on the original footprint and failed to do the additional 40 feet. Sure enough, somebody falls asleep at the wheel and goes off the road where that replacement and extension, where the extension was supposed to be. And the child was left very badly injured because of that failure, a clear breach of the contract, no doubt. That That's why the kid was hurt so badly, because there was no
Okay.
addition. So it was that dangerous before and after the contractor performed its work. So we didn't make it more dangerous. I think the Supreme Court totally had it right on the force of harm issue and the spoliation issue. Our office was underwater all day. There was a state of emergency flood. We didn't do it on purpose, and we gave them the log anyway. So that's all I have, unless your honors have questions.
Thank you.
Thank you.
991 through 994. Smith versus Smith. We did.
May it please the court? I'm here on behalf of the defendant, Anna Smith. There are several
Ms. Kennedy,
decrees.
good morning, or good afternoon. Yes, still
Good
morning.
afternoon.
Yeah.
Almost afternoon. No, it's still morning. So, almost afternoon.
There are several decrees of the lower court.
Let me just interrupt you real quick.
Sure.
If I can. And if, I don't mean to steal your thunder, I know you want to lay it out, but you've been in front of this court enough to know that we're familiar with the issues and the record as best we can. But
And have sat on this case before.
That's right. So fundamentally, this is how I look at your appeal, and where I missed something, please let me know. Fundamentally, you're saying, wait a second, before you make this decision, you got to hear all the facts. Right, or no?
So, because, I'm switching it up a little bit, Your Honor, because
right.
there are 4 different decrees that are on appeal here, what I'd like to do is focus on the most recent one, and that is the lower court signed an interlocutory judgment in May of this year where he said, okay, this property is going up for
Right,
sale.
it's going up for sale, and I'm not giving you a hearing.
Not for
and that's too
partition.
bad. And what you want at least is to have a hearing to see if partition is a possibility.
So,
Because a lot of the testimony, or a lot of the, not testimony, evidence has shown that that might be the best way to go about this. So you want a hearing to make sure that at least that's heard.
I want to go one step beyond that, Your Honor. I think if you look at the statute, a partition is a creature of statute. It's all set out in Article 9 of the RPAPL. And 915 says there's an absolute presumption in a partition case in favor of a physical partition unless the party opposing the physical partition overcomes that presumption by showing great prejudice to the owners, not one owner, both owners.
How would you do that in a hearing?
So I think, because if I think that their burden was on, at this point in time, to show great prejudice, and they didn't. And if you look at the case law, how do you show great prejudice to the owners? In the cases that they cited in their brief and that we've referred to as well, you do that by showing that there is a diminution of the value of the property as a whole if it were to be partitioned. You look at Laughlin versus Cruikshank.
Right, so, but you need somehow to get to that.
They have to overcome the presumption. And I think, based on this record, here's what the big problem is. They have an expert report that clearly says there's a title in their expert report, fair division of the pocket layer.
We understand that.
So with that, before the court, we think that the lower court erred as a matter of law in finding, the court said, this is too complex, this is too complicated. We have to have a sale, can't deal with this. If this were to go back, what relief we're asking for is for this court to modify the interlocutory judgment and instead of directing a sale, to direct a partition. At that point in time, it goes to commissioners. Under 921 of the RPAPL, you appoint commissioners. The commissioners are the ones who listen to the evidence, who in essence have the hearing. The commissioners are the ones who decide, can this property be divided? How should this property be fairly divided? Presumably, the experts would testify before the commissioners. Presumably, they would testify.
You're saying you wouldn't have to send it back for a hearing because the commissioner would do it.
And there's a fail-safe. in the statute. If you look at 922.3, if it goes to the commissioners, if they hear all the testimony and for some reason they decide that, you know what, we can't determine how this can be fairly partitioned, they make a report to the judge, and at that point in time, the judge has the authority to issue a supplemental interlocutory judgment, and he says, you know what, it's going to sale. But what we're saying is procedurally, it does not have to go back. We're not asking that it go back to the lower court for a hearing. Our position is that the other side failed to overcome the statutory presumption, as a result of which we go to the next step in a partition, which is a hearing before commissioners. Okay? Thank you. Unless there are any questions? Thank you.
I think we're in afternoon now, Your Honors, right? Good afternoon. Dan
At
Powell.
noon, you can say good noon.
On behalf of the respondents, just to briefly respond, there's nothing specifically set out in either RPAPL 915 or 921 saying you have to have a hearing. And I think what's important here is to understand that if you go back to August, the court had a 2-day hearing.
How do you determine there's prejudice without a hearing?
Well, in this case, he used the expert affidavits.
But the expert said there's no prejudice. What you should be doing, the partition is fine.
Yeah, I think, Your Honor, if I may, I think what happened, what our expert on the respondent side said was that he called it a simple solution, right? And what he said was, okay, there's this pocket layer, and the pocket layer is where the majority of the value is on the property. That's where the easiest access to the minerals are. So if you wanted to equitably divide the pocket layer, you just run north to south, you cut off a third at the bottom, and give the respondents 2/3 at the top. He didn't get into the weeds in terms of, okay, if we're looking at the entirety of the 52 acres east to west, what is equitable in terms of that? What he opined on is, if we want to equitably divide the pocket layer where most of the value is, we could do that. He didn't talk about, if we're going to do that, is that going to leave one or more of the parcels landlocked? Is there going to be ingress or egress issues? He didn't get into any of that, right? So I think it's a little bit of an oversimplification to say that all of the experts said this could be equitably divided. I think that's one way to look at it, but looking at it in the context, I don't think that's what the record shows.
Okay.
And if you look at it back to August, there was a 2-day hearing in August where the parties put together proof, where they presented proof in front of the trial court to talk about the nature of the property, the history of the property, the fact that there was parcels before and it was...
I could give all that to you. I've been in this case.
Yeah. and so what the lower court decided come December was, okay, all I need is expert reports. I have the parties' testimony over the course of 2 days back in August. Let's see what the experts have to say, and then I'll make a decision as to whether or not there would be great prejudice. And what the lower court said in its discretion was based on all of...
Did he say, I'll decide if there should be a hearing?
I'm sorry, Judge, one more time?
Didn't he decide whether or not there should be a hearing in the future?
That's right, and what the judge decided. Back in August, he said, let's get together in December, and we'll decide whether or not. If we want to have a hearing, maybe we'll do that. We could do that. That's possible. And he decided come December that it wasn't necessary. And that was after he had heard the parties testify. It was after he had read the experts' reports. And in his discretion, the lower court decided, we don't need to have a hearing. I know, based on the evidence that's in this record, that we can't equitably divide this property without great prejudice to the parties. That was the court's decision. He was asked, can we have a hearing? And he said no. And that was within his discretion to do. So unless there's any questions, that's all I have. I'll rest on my paper.
Thank you.
Thank you, Your Honors.
995, Stacy Combs versus Julie Medeski, et al. And you can say good afternoon.
I'll try not to take up too much of your time. May it please the court, I'm Kathleen Sweet. I'm here on behalf of Dr. Julie Medeski and Artemis Medical. It's our position that her summary judgment motion should have been granted by Judge Sedita. I'm sure the court is well familiar with the facts, but briefly, this was a robotic-assisted ovarian surgery performed by a board-certified gynecologist. In opposition to the summary judgment motion of my client, we have an affidavit from a general surgeon who has never, or at least he does not aver, he or she does not aver, to have performed a gynecologic surgery of any kind, never mind a robotic-assisted ovarian surgery, never assisted at one, never attended one, never observed one. Never even says in the affidavit, I've read up about this, I've watched one on YouTube. That is insufficient to lay a foundation such that there's anything reliable about the opinion that flows from that expert. Plaintiff cites a series of cases from this court, 4 cases, every single one of them distinguishable. I'll start with the most recent one, Sanchez, where this court in June found that the plaintiff's expert was qualified and laid a foundation that was proper because the plaintiff's expert was an emergency medicine physician with over 40 years' experience, and the opinions he or she was offering were in the subject matter of emergency medicine, where the defendants were physician assistants functioning in the emergency room. The court properly held that that's an adequate foundation, that that expert's opinion is sufficiently reliable. In 2021, in a case called Revere, this court found that the foundation was acceptable when the plaintiff's expert was an internist, but not an allergist like the defendant. And why did this court say that that was sufficient, that that type of foundation for that expert was reliable? Because that issue in that case had nothing to do with the actual specialty of an allergist. That was about a duty of one physician to communicate with another physician. It didn't have to do with the idiosyncrasies of an allergist. Moving back 2 years before that, there's a case called Wick. The defendant was a radiologist interpreting x-rays of the left foot and the joint of the lower extremity. Defendant radiologist moves for summary judgment. Plaintiff's expert in opposition is an orthopedic surgeon. This court properly held that such an expert can lay a foundation because of their experience.
Okay, I think we understand. I think we got that now.
Ms. Sweet, we do have a radiologist.
Counselor, can you get, go.
Okay.
Yes, Judge.
Counselor, I was going to ask you about the contrast issue. Can you address that?
So the only issue that remains as to Dr. Medeski at this point, the only issue not abandoned by the plaintiff, is the choice of surgery. The issue with regard to contrast, I should leave to my friends that are yet to speak, but Dr. Medeski did absolutely everything correctly with regard to the issue of the contrast. She gets word in the early evening after the patient has been discharged that her patient has had a sudden onset of pain and fever. She tells her patient to immediately go to the emergency department. She calls the patient's own surgeon, who had just recently done a GI procedure on the patient, and says, I did this case, this ovarian surgery today. I sent the patient to the ED. Is there anything else you think we should do? Anticipating that there may have been a complication that a general surgeon may have to address. The general surgeon, Dr. Hodge, who is familiar with the patient, says to Dr. Medeski, when you get the CT scan, make sure they use contrast. Oral, IV, and rectal. And make sure they get the rectal contrast, because that will show if there's a perforation of the colon. So Dr. Medeski calls the emergency department, speaks with the staff in the hospital, and says, my patient is there or on her way, make sure the CT scan is done with contrast, and insists that rectal contrast be used. There's nothing more that she could have or should have done, and that is
She's not supposed to follow up on that at all.
Well, she's not the ordering physician at that point. She communicated that recommendation to the emergency department. The emergency department physician, Dr. Kowalik, ordered it as she recommended.
But Dr. Loftus's expert, Dr. O'Haron, and I'm referring to page 1155 of the record, said that it's the duty of the requesting and ordering physicians to review all radiologist reports to make sure their instructions are being followed. And so isn't Dr. O'Haron implicating Dr. Medeski?
Well, the reports don't say that there was a perforation, though, Judge.
No, but the report doesn't say that as to what contrast is being used. That's not something that Dr. Medeski should have followed up on?
She did. The very next day, what she did was she went to the radiology department and met with Dr. Loftus, and he acknowledged at his deposition that she's exceedingly conscientious and that it's not unusual for her to say, show me the films, this is where I thought my trocar may have entered the fascia. Do you see anything suspicious there? And he says no. There's a little air which is consistent with the amount of insufflation you have to do with every laparoscopic procedure, and there's a little fluid, also consistent with the recent surgery.
I don't disagree with you that Dr. Loftus didn't make mention of the lack of rectal contrast either. Dr. D'Souza did. The next radiologist came in and said, oh, this one didn't have the rectal contrast. That's why it didn't show.
Right, and that's a conversation that, again, was initiated by Dr. Medeski. Dr. Medeski is conscientiously following up on this to investigate what's going on with her patient. And all that is highly relevant to a discussion that is yet to come with my colleagues here. Has nothing to do, with all due respect, to the only remaining question that exists as to Dr. Medeski. As the case exists right now, if we were to go to trial, question number one and the only question is, did she do the wrong surgery according to the general surgeon who has zero alleged experience with gynecology?
Got that.
If there's any other questions? Judge Curran, you look like you have a question.
No, but thank you for observing me. Appreciate the attention. You know, let me think of one.
And I'm shocked.
See, I knew I was going to get that reaction from the justice. I spared you that.
And mercifully, no Bill's comments.
Yeah, please, especially where we live.
May it please the court, Teresa Walsh, on behalf of the plaintiff. I know I have two aspects to this motion. Obviously, I'm responding to Ms. Sweet's appeal, and I also have an appeal of my own, so I guess I will start with Ms. Sweet's appeal since that's the first on the docket.
I agree with Ms. Sweet that there's only one issue pertaining to her client at this point.
I don't agree with that. I mean, we certainly appealed it all, you know, and sequentially, we talked about different issues in the appeal, but we certainly said in our appeal that we disagree with the dismissal of the remaining post-operative care, not only with regard to the CT scan, but the fact of, you know, the discharge, the failure to follow up, the other things that could have been done by Dr. Medeski to detect this perforation earlier, beyond what we're talking about with the CT scan. That is outlined in my expert's report and touched on also in our brief. So I disagree with that point of it, I guess.
Well, doesn't the affidavit of Dr. O'Haron help you with respect to, I'm looking at paragraph 25, I think, at page 1155 of the record, where that expert for Dr. Loftus and Eastern Niagara says, it is the duty of the requesting and ordering physicians to review all radiologist reports to ensure that their instructions, directives, and orders are being followed. I read it correctly, didn't I?
You did. I would agree. So I think that goes to that point and going and then starting from the original point about the remaining claim in the case. I think we've laid it out in our papers that this is not, it's not specific to OBGYN. This specific issue is regarding, you know, the general surgical concepts of what you do in this area of the body. And so my expert was addressing it in relationship to laparoscopic.
If you think you may have perforated the colon during your surgery, and there was some suspicion of that as I read the record,
Yes.
then you should make sure you order with renal contrast.
Right.
And Dr. O'Hara says, make sure it was done.
Right, well, yes, that's the concept of, in terms of what's going on here, is that basically,
And a surgeon could opine as to what should be done, a general surgeon, as after the fact. That was really the point I was trying to make.
oh, yes, Your Honor, that's correct. And in going to the original argument there, I think the surgeon can opine to the appropriateness of these two different laparoscopic versus open procedure. That was outlined in our expert affidavit, so I won't go over that again. But to the other point is that Ms. Sweet's expert did address it. And there's no relationship to the fact that it was just in context of OB/GYN procedure. My expert said.
You made that clear.
So, going on to, I guess, my appeal, because that's the rest of my argument. I think we outlined our argument with respect to Dr. Kwok, which I think is one of the biggest issues in this case, that Dr. Kwok didn't even move for summary judgment, yet got some kind of windfall benefit that Dr. Kwok never sought or obviously thought he was entitled to, because he had his own opportunity. He had a highly competent counsel, and we outlined what Dr. Kwok did in this case, what he missed in this case. We put them in the facts about he ordered it. He looked at the report, and then didn't address the fact that his oral record contrast wasn't done. So, that being said, under all those circumstances, he didn't move. There was a reason why he didn't move. He didn't think he was entitled, but he got a windfall from that. So we think we did not have the opportunity to address that. We think we got a lack of due process. We did outline the cases addressing that, if your honors have any further questions about that. But I think that is pretty much set out in our papers and is a pretty strong point and an issue for us in this particular matter. Going to the aspect of Eastern Niagara and Dr. Loftus, I think the biggest point I'd like to make is, I think the most evident one of my papers is they didn't meet their burden, especially with regard to what happened in the performance of the CT scan. The reliance of the trial judge on the new facts that were invented for purposes of this motion that were not testified to, that were not in the original record, and calling that is the fact, that is the undisputed fact, that was the whole basis for the decision. Not only was it a decision, but it was the whole basis for their expert's opinion, even though Mr. Van Pelt testified to something totally differently and made a whole totally different story when he came before the court on the motion. That was totally disregarded by his expert. His expert doesn't mention it all, glosses over it, contorts himself in a pretzel to try to explain that away, and only relies upon the fact made for the first time that it wasn't available. Maybe it was August, September, maybe it was before August. His affidavit says two different things. So I think based upon that forms the whole basis of their opinion. They didn't meet their burden. And even if they did meet their burden, my expert radiologist certainly, met and addressed every single point made by their radiologist with respect to the administration, the rectal contrast, the failure to follow up, and the proximate causation issue. So that's this traditional battle of the experts right there. And I think if your honors have any other questions for me on the other points in my brief, I think I can rest on that.
Thank you.
All right, thank you.
Good afternoon, Hedwig Arletta on behalf of Dr. Loftus and ENH. If it's all right, I'll begin with Dr. Loftus. The arguments are slightly different. Dr. Loftus was the radiologist, as you know, and we submitted an expert affidavit of Dr. O'Haran, who defined the duties of a radiologist. As you might expect, he's supposed to accurately read the films and accurately report on the films. The plaintiff's radiologist expert did not disagree. He did not read Dr. O'Haran's affidavit. He did not mention Dr. O'Haran a single time. He did not discuss any of Dr. O'Haran's opinions. A competing expert who doesn't read his opponent's expert's affidavit, that expert opinion is not worth anything. And in addition, the plaintiff's expert completely disregards several important facts. So Dr. O'Haron laid out the duty of an expert, of a radiologist. Okay. So plaintiff claims, and I'll address something that was just said about invented facts just for the motion. She is referring to Mr. Van Pelt, the technician. He testified, and he also put in an affidavit. They are not contradictory. There is nothing wrong when you're making a motion with submitting an affidavit. The facts were not invented for this motion.
Ms. Aletta, I thought at first he testified that it wasn't ordered, that the rectal contrast wasn't
He
ordered.
never changed that.
And then later, but then later I thought he said that it wasn't available, we didn't have it.
But they're not mutually exclusive. And during his deposition, and remember, the facts in this case, sadly, took place in 2013.
Right, I understand. But if the hospital didn't have it, why did Dr. Kowalik, who's working at the hospital, order it? Why did he order something that the hospital didn't have?
I don't know. Dr. Kowalik, perhaps, taking the order from Dr. Medeski, says, oh, she wants this, this, and this.
She does surgeries at the hospital. She thought they had it. Dr. Hodge did the colonoscopy, thought they had it. They all thought they had the rectal contrast, and now we have an affidavit indicating that, oh, we never had that.
Well, he doesn't say never.
Okay.
They had it for a time.
Fair enough.
Okay, but that's not critical to the argument. First of all, it's not made up. This is his recollection. He had a recollection at the time he gave his deposition, and he never deviated from that. That's not what I got. Maybe it was on the doctor's mind, maybe Dr. Kowalik wrote the order that way. I get a requisition, that's my instruction, and it wasn't on there. So it's not like, oh, never mind that testimony, we didn't have it. And as far as Dr. O'Haron relying on that, that's all he says, oh, well, they didn't have it, okay, that's the end of the story. That's not true either. Dr. O'Haron said the IV and the oral modalities do the same thing. He talked about, or Dr. O'Haron talked about proximate cause, and Dr. Loftus himself addressed the issue of proximate cause, which I'll get to in a minute. The testimony, undisputed testimony from the technologist is, that wasn't my order. So that is not a means for an expert. An expert doesn't say that, have to say that. The technologist said, hey, I did what I was told to do.
Okay, I think we have that.
Oh, the plaintiff's expert does not disagree. The plaintiff's expert at paragraph 11 says the technologist got three things: the requisition, not the order, he had access to three things, but he got the requisition, and later on he had the report from the Nighthawk people, the overnight people who read the thing, and then his own one-page report where he records the IV contrast. That's what he had. And the plaintiff's attorney expert agreed with that, and that's what Dr. Loftus got from the technician. That's what Dr. Loftus has. And yet, many paragraphs later, with no intervening discussion, the plaintiff's expert says, oh, so Dr. Loftus knew. He knew that it was ordered, that rectal was ordered. He doesn't explain how. And indeed, Dr. Loftus testified he did not. Dr. Loftus testified he doesn't even have to look at the requisition. He gets the film. That's what he looks at.
Okay, I think we've got that.
Okay. And then they talk about notice. Well, first of all, you don't give notice of something that you're not aware of. And second, both Dr. Kowalik, and you know that, got notice that he got a copy of that report that says what was used, and he got it while he was still on his shift, and he said, I didn't put it aside, I read the whole thing. So Dr. Kowalik, the ordering physician, got it. And Dr. Medeski, she is conscientious. She did go to see Dr. Loftus. They looked at the image together on the screen, and she said, well, I didn't notice rectal, but I wasn't really looking at the colon. You can't not see.
Okay.
It's right, it's in the same place.
Okay.
Okay. So they both got notice. As far as the technician, he got his requisition form. Yes, the form that we had at the time of the deposition was not the greatest quality, but the technician said he didn't see anywhere, well, oh, look, here's some words I can't make out. That's exactly where rectal would have been written. There was nothing like that. He said, there's nothing on here that suggests to me that
we
rectal was
understand all
written
that.
in. So he didn't have that.
The reason I'm saying this to you is because we have all of it.
I know.
Okay.
But so did the trial judge, and I still lost. The notice is the same, right? They both got notice. I'll try to talk a little faster. As far as proximate cause, the plaintiff says, oh, Dr. Loftus agrees with us. Wrong. He agrees if you chop out all the qualifying words. Dr. Loftus says, if, may, might, potentially, rectal would have helped to reveal this. So Dr. Loftus doesn't agree with him. Dr. Loftus, the very last exchange with the plaintiff's attorney says, so rectal would have helped, and Dr. Loftus says, may have helped. So,
What I'm going to tell you right now
yes?
is that you have just a couple minutes left, so. do you
Okay,
have
well, I'm on proximate cause, it's my last thing. Oh, see, now you threw me off.
And I'm not trying to shut you off, what I'm trying to tell you is, again, we have,
Okay, well, all right, so Dr. O'Haron's, our paid expert, said, you can't say definitively, it would be speculative to say it would have. And the, again, plaintiff's expert who never read Dr. O'Haron, never heard of him, he was required, instead of simply to say conclusorily, oh, it would have revealed the thing. Would she have accepted it? It's uncomfortable, it's nasty. Would it have gone up to the place where the thing was? Would she have tolerated it? Would it have even been seen? It was a teeny tiny size and it was hidden in stuff. And he didn't mention those things, and without mentioning them, his opinion is deficient. You can't ignore facts that might be bad for you. That's it.
thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, I'm here on behalf of Dr. Kowalik. There's really only a single substantive issue, I think, on this appeal with respect to Dr. Kowalik is, was it the same issue before the court presented on the co-defendant's motions that the Supreme Court based their ruling on? And we respectfully submit that the answer is yes. I mean, even the plaintiff in their brief say at page 47 that the non-administration of the rectal contrast, which was unquestionably ordered and undisputedly not admitted, is the key issue, not only to the hospital's liability and Dr. Loftus' liability, but also to Dr. Kowalik's liability. And I'd also refer the court to the Supreme Court's decision on the proximate cause issue, that we spent a lot of time this morning discussing allegations regarding deviations from the standard of care, not as much talking about the court's proximate cause ruling. And obviously, we weren't a part really of those motion papers, but I'd refer the court to that. The plaintiff's expert affidavit was patently insufficient to raise a triable issue of fact. Just briefly address, there's no dispute in this record that Dr. Kowalik ordered rectal contrast. I think that there's some suggestions and, co-respondent's brief that there was a requisition versus an order. Nobody disputes that. Even Dr. O'Haron in paragraph 23 of his affidavit. And briefly, the plaintiffs refer to issues of due process. The Supreme Court, as this court is aware, is empowered to grant summary judgment to a non-moving party after searching the record. Due process is not implicated, except in cases like the Gibbons case that the plaintiff cited in their reply brief, where there were completely different defenses. In that case, it was a contractor who had renovated a bathroom, and the owner, or essentially operator of the premises, plaintiff fell in the ladies' room. They had two completely different defenses, and there, for the court to search the record and award summary judgment to the operator of the restaurant violated the plaintiff's due process. And that is not what we have here. Here, the issue is all about the rectal contrast, and when the co-defendants were granted summary judgment with respect to the postoperative care, Dr. Kowalik was properly granted summary judgment also, and we ask you to affirm.
Thank you. 996, 65 Lake Avenue versus Lender Consulting Services, Inc. Okay. Me too. One second, we gotta wait.
There we go.
Okay.
Great. May it please the court, my name is Steve Williams, and I represent the appellant here today and the defendant in the underlying action, Lender Consulting. This is, as the court knows, a statute of limitations case. The plaintiff is seeking to dodge the statute of limitations, and I think it's important to take a close look at the statute that the plaintiff is relying on, namely CPLR 214C. I have a personal history that relates to this particular statute, and what do I mean by that? As a boy in the late 60s and early 70s, I lived a couple miles down the road from the Love Canal developments in Western New York, and anybody from Western New York knows what that's about. That case was about companies illegally dumping toxic chemicals that later poisoned people decades later.
We all know what it was.
Perfect, perfect. So you know that it was that cases and cases like it that led to the toxic tort legislation in 1986, including CPLR 214C, and I know that too because I was a legislative staffer in Albany when that legislation was passed. And it was designed to protect people who were poisoned by illegal dumping, and they were poisoned decades later. Well, this case is nothing like that. This case is a claim of professional malpractice where the plaintiff alleges my client failed to identify some toxins in the soil and then sued my client for that malpractice, not within the 3-year statute of limitations, but 16 years later. Now, the plaintiff is desperately trying to dodge that statute of limitations 3-year limit, and in doing so, they rely on 214C. And I respectfully submit that the court below incorrectly applied 214C to this case.
Counsel, sure. It seems to me that you're focusing on the plaintiff's allegations that LCS admitted that they didn't test the same area in 2005 that they later tested 2018, 2019, the years later. But the plaintiff's also claiming that the contaminants moved because of these pathways. Why can't both be true? And in fact, don't we have to assume at this stage on a 3211 motion that both are true?
Yes, Your Honor, but it doesn't change anything. And what do I mean by that? Let's assume for fun that the toxins moved. The movement didn't create any new or additional harm. It's still the same contamination at the location on the site.
The plaintiff isn't claiming that the movement did cause harm?
The only harm that the plaintiff is claiming is additional remediation cost, and we know from the Germantown case that additional remediation cost is not the kind of harm contemplated by 214C. And if Your Honor will allow me, I'll quote from the complaint, because this is the pivotal language.
You don't have to quote from the complaint.
All right. Well, if I might just highlight one thing. The plaintiff alleges that utility conduits have acted as a preferential pathway for dangerous contaminants to migrate. Now, they haven't alleged that they actually migrated. They said there are pathways for them to migrate. And then they say, which could pose a direct health threat to residents. And they don't allege that the residents were harmed. They just say it could happen. Yes, a lot of things could happen. They could migrate the contaminants through those pathways. It could harm those people. But they don't allege they did happen. So 214C does not apply. If the contaminants migrated and harmed those residents, perhaps then those residents would have a case here today where the statute of limitations would be told. But this is the developer. And the only way the developer was hurt is that this land was contaminated. It was contaminated before 2005. It was contaminated after 2005. And it's still contaminated today. And based on the developer's complaint, the only harm they're claiming is it's going to cost a lot of money to fix this. And we therefore respectfully submit that this case should be dismissed based on the statute of limitations. And unless the court has any other questions, we'll rely on our brief.
I'm back to Germantown. You said it doesn't apply to remediation costs.
Correct, Your Honor.
Where does it say that in the case?
Well, the case exactly stated, and I don't have the quote, Your Honor, but
okay, I'll look for it.
Please do, because it did address additional remediation costs, and that's not something contemplated by the statute as a harm.
Let me ask you this, Mr. Williams, too. So is this issue of statute of limitations still alive at trial, if you go to trial? That is, could you argue that this harm is too late and this harm is not?
I would respectfully submit not, because based on the allegations of the complaint, there is no issue. They haven't even alleged facts necessary to create a question on that. If they had different allegations, maybe, but based on the allegations, they don't claim any new harm from the passage of time. They claim the contamination is still there, and maybe it moved, but that movement didn't harm anybody. They just claim it might or could harm somebody, which I respectfully submit is insufficient for the tolling of the statute of limitations. Thank you, Your Honors.
Go ahead.
Thank you, Your Honors. This is Richard Moore on behalf of Respondent. Frankly, I find the prior argument a bit confusing. The argument is apparently implies that 214C does not cover damage to property, but only damage to person. That's not accurate. 214C clearly covers damage to property. Defendant clearly admits in their brief that Germantown is the seminal case and leading case in New York on this issue, and simply chooses to ignore the clear language within Germantown that it explains the exception that 214C is relevant to. And in terms of motion to dismiss, the allegations of the complaint have to be assumed to be true. We allege, and I submit accurately, that there has been migration of contamination through these preferential pathways. That migration has further damaged the property. The apartments that were built on the property have had infiltration into the buildings. We have had to work out a plan with the DEC and
Mr. Moore, can you hear me okay?
Yes, I can.
The same kind of question as I had for Mr. Williams. Is this issue about timeliness still alive at trial? That is, it seems to me the defendant can still raise it and say, hey, we have to find out. It could be a jury question that says, this harm is too late. When did the harm occur? So it's still, even though you won on this motion, it's a motion to dismiss. The issue is still alive in the case, right?
Your Honor, actually, I'm not sure that's the case. I believe the issues of tolling is either the tolling applies or it does not, in which case we have not, the statute of limitations issue I don't believe is still open. The nature of the damages perhaps would be something that would be contested in terms of what was the extent of the increased contamination, the increased damage to the property. That would be probably in contention.
Okay, anything further?
Yes, it's somewhat bewildering for me to simply ignore the language of Germantown, which defendant has asserted is the leading case. And I believe the allegations in the complaint are very straightforward, fit directly within those requirements, and submit that the court below was entirely correct.
Thank you very much.
Thank you.
Thank you.